I'm ashamed, my lord. I'm disturbing your lordship, my lord. I'm mentioning item 77. My lord, that was a matter, my lord, your lordship had earlier given me leave because it was an urgent matter. But every day it is receding.
Because of the other matters, other important matters are coming up.
My lord, but I am going to be victim by virtue of an order which is totally, my lord,
What kind of challenge is this?
matter?
Oh, recognition.
Yes.
That is a hearing. I have possibly I have directed to file the affidavit. Without affidavit, it cannot be decided.
My lord, your lordship,
Any
the earlier writ application, your lordship dismissed because there was a report that the approval.
I remember the report after considering the
Against that order, your lordship, my lord, directed. Your lordship desire was that a new writ petition has to be filed.
obviously, after consideration of that report,
Not only that, by virtue of that illegal order, my lord, very drastic measures, coercive measures are being taken against the matter, sir.
what kind of coercive measures
First
there?
of all, my lord, because of that illegal order, now, my lord, a step is being taken to stop the salaries of the teachers. 300 students, where they will go?
Item number?
It is a matter, item number 77.
This week there is a
My
difficult.
lord, your lordship, pardon, my lord.
Yes, I have taken note of it.
My
I
lord,
have
your
taken
lordship
note
will
of it.
kindly indulge me because your lordship has indulged. I do not know who determines the list of this court
Why?
because I had been to the Chief Justice, my lord, the learned Chief Justice. In one of the learned judge's bench, it was written, without the approval of the learned judge, no matter will be included. I showed it to the Chief Justice. The learned Chief Justice asked me, yes, Mr. Ali, what does it mean? And I do not know what does it mean.
No new matter possibly that has been meant.
No, it may be. It may be. But the judgment of the Chief Justice asked me how much. I said 8,000 per matter. And the next day the determination was changed.
No, Mr. Ali,
The
this
Chief
is.
Justice asked me how much.
Mr. Ali, there may be a situation. You are experienced enough to know.
My lord,
There may be a
in
situation
my-
where new matters may not be the new motions. Some inclusions may be restricted.
No, that is right, my lord. That is right.
The court
My
will.
lord, even one day it so happened, your lordship said that I would take up to 53. Mr. Badi is there? No. But unfortunately, Mr. Badi was there. You want to say? But a matter, Mr. Badi had a matter just one ahead of me. And it took the whole time. I told him,
It is his skill that he took the
"What
whole
happened
time.
now?"
He took the whole skill.
So, my lord, item 7,
I'm taken note of it. I have taken note of it.
kindly fix it that you can.
I have taken note of it. You can ask your junior to keep watch over the
Because
list.
last time, my lord, I mentioned because I had to go out of Calcutta.
I remember.
Cancelled my doctor's appointment for this
You
matter.
should not. You should not.
Yes, my lord, for this matter only.
I have
Let me be
taken.
honest to myself.
I have taken note of it, Mr. Ali. If you have any confidence on the court, please leave. I will consider it.
I apologize to your lordship for mentioning this matter again and troubling your lordship. I mentioned this matter on Monday, your lordship. This is an application of a retired headmaster of a school who has not been paid a single for.
Haven't you take note of that? The Monday is the only date for mentioning.
I mentioned it on
If
Monday.
you have mentioned, you have to wait for your turn.
Lordship,
If you have mentioned, don't mention it. If you have an so urgent, I am releasing the matter after.
no, your lordship, only thing is that your lordship allowed the mentioning. But when I inquired your lordship, the officer said, your lordship officer said that it will be included in the monthly list. So only I'm one thing, humbly I'm beseeching your lordship, if a date can be fixed or it can be kept under anything to be mentioned. Only
Don't
that
repeat your mention. Don't repeat your mention. All insurance slips are in the queue.
Lordship.
Please don't mention it.
I apologize for that.
And today is the last day for filing evidence. When certain documents we have collected, some important documents are very much required for effective disclosure of the information. I said it will be praying for extension 1 week for filing evidence.
The matter is appearing in the list.
That matter, my lord, where the board directed that the patient rooms. Rule of
Hearing has been fixed,
that has been fixed on 9th. And today is
9th or 11th.
no, possibly, my lord, the 9th. Two matters, one 9th, one 11th. So, my lord, this is 7897, what the schools file a repetitions, praying for that non-applicability as the school is unaided. The malady also was kind enough to grant me opportunity to file the affidavit with 3 months. Seriously, today is expired. If your lordship remember, no problem. But
No, this so far because this is a very correlated matter.
Yes.
And one of the matters
And
of the
based on-
school, the board took a stand that
That
this
is-
rule
that
does
is
not
not mine.
apply.
that
That
is-
has been already been disposed of, I suppose.
both the matter are pending. Both the matter. Huh. Both
Mr. Baird,
the.
Mr. Baird is applicant.
Yes, that was a challenge to the that some observations of
Yes,
you
yes.
that ultimately that was not
No,
disposed
no, no,
of.
it has not been disposed of.
And date of hearing has been fixed by your lordship.
Nine, the date of the fix for hearing, and today is expiring the filing of opposition. Today is the last date. That's why I was drawing. I have tried my level best to collect the all papers, but it is very much,
9th or 11th.
no.
Is it proposed?
Disciplinary proceeding which went up to the Supreme Court, that is the different issue whether the disciplinary proceedings will continue from that
No,
stage.
that your challenge in that writ petition was that disciplinary proceeding, that rule should be followed.
Yes.
But since the board is saying that rule has no
No, that
applicability,
is very important, the board's decisions, board's.
already taken a decision, board.
That is the stands before the other court, board stands, yes, we have the authority.
No, no, no.
We are, no, no, anyhow, that's why,
No, these two matters are required to be heard together.
no, your lordship's one matter fixed from 9.
No,
another matter fixed from 11.
if
Of the
these
same
two,
school, of the same
Same-
school.
same.
The both should be had together, your lordship, because same issue.
yes, same issue. 11th is the date fixed. Let it come on 9th. Let it come on 9th. You comfortably prepare your affidavit in opposition on 9th when the matter will appear. I will extend the time on 11th. On 11th, you will be getting your affidavit filed out of time will be accepted. Sub the advance copy on the other side.
Well, that I
Call
can-
the list.
that is well, the time is being taken for preparation.
Let you take now. You prepare it. You prepare it.
Dina Mitra,
Very-
two matters.
Very.
Their lordships kindly to mention two matters pertaining to administrative transfer between lordships. The identity was with that.
Is it any meaning carries the note on the list, on the top of the list? Are you short of your eyesight? Next, call the list.
Number 3,
I take on behalf of the petitioner, your lordship.
And for the secondary board, your lordship.
On the last occasion, it was your lordship's pleasure to direct the GIP of the report indicating the vacancies.
And in district Birbhum.
Yes.
My lord, it appears, my lord,
Wait.
there are 6 vacancies, my lord.
Oh, single cater post, there is no necessity of categorization. This was the view of the DI of schools. But Dr. Patro differs.
Yes, sir, Dr. Patrick is appearing for the.
Dr. Patro differs, no categorization is
Required,
necessary.
required.
That's why, my lord, I am saying, my lord, kind
How
of
will
seen, my
connect?
lord. It has been categorized, my lord, and
Categorization হয়েছে করেছিস?
হুম।
সেন্ড করে দিয়েছিস ওদেরকে?
Now, this is giving another angle. According to this report of the DI, the board is maintaining a roster.
Lordship, this confusion is creating every time. I even previous occasion I submitted lordship. All the vacancies are after the amendment of 2018, it is the board who has been engrossed to maintain a roster. But my lord, for that vacancies must be with the board and the vacancies are to be sent by the DI. So my lord, we have received vacancies of 9, 10, 11, 12, headmaster, and in upper primary only Shantali language. So whatever vacancies we have received, we are categorizing the same. The roster, we are preparing the roster, whatever the procedure is to be followed, we are preparing the roster of that. But in case of group C, group D, as because compassionate appointment mostly are in group C and group D, well, we don't have any vacancies because we have not received any vacancies.
Roster you are not maintaining.
No, because we don't have the vacancy. And
You
your
are
lordship,
not obliged to maintain the vacancy.
until and unless we receive the vacancies from the DI or the education department, we don't know how much vacancies is there.
No, obviously,
Yes. So
But-
we have not received any vacancy from the education department, from the DI.
supply him, have you got the
Yes,
report?
yes.
What does it say? Kindly explain.
Well, this is the thing, your lordship, because I have
The
submitted this.
school education department of West Bengal Secondary Board is the appointing authority of the headmaster such and such, such and such. And as per rule 3 or F of the said GO, West Bengal Board of Education is being appointing authority, maintain the reservation roster of the post in respect of teacher and non-teaching staff, including liability.
I am not disputing it. After amendment of 2018, board is to maintain, provided board gets the vacancies from the DI. Board have received only vacancies of 9, 10, 11, 12, headmaster
As received.
has received the vacancies. That we are, that roster we are
Now,
preparing.
if this we can see, what he is saying, that out of this
38.
38 vacancies, out of 30, within bracket 40,
The mistake something. 38 is there. Because it appears from the next page is 38.
6 vacancies occurred before 2018 are duly authenticated by the PO.
Authentication must be done by BCW.
Please look into that.
No, that is not.
By the PO, come DWO Birhum. The report which is proposed to submit today, first paragraph. Now these 38, not 40, 38 vacancies, 6 has been categorized.
Categorized by the BCW. They have sent the DI
6.
6. So if
Remaining 32 vacancies to be sent to whom for categorization?
BC, they will send it to the BCW. They will because my lord, these are the not new vacancies. What after 2018, what are the new vacancies are created? That will be for us. But these are not the new vacancies. This is for because we
Understood. From the board, BCW will send it to board of the board.
no. Well, rule is they will send it back to the DI. Then DI will forward it to us. We will send to the SS.
Commissioner of School Education.
Yes, DI will send to the Commissioner of School Education. They will send to us, and we will send. to
Rule
the-
provides so. Show me the rule.
No, when I can't show anything that is in the rule. BCW rule, my lord, there is a BCW rule which provides, so then I'll come back with it on the next day. There is a rule of BCW rules which says so. 2018 rules does not utter a single word regarding it. Only a single line is written.
And
board is to-
the person who is seeking compassionate appointment will go into from this department to this department to that department.
Well, as your lordship in the other compassionate appointment matters directly.
Do whatever. You travel through your every department, I don't mind. But this already 6 vacancies are
Yes.
categorized.
Send
So,
it to the SSC.
you send it to the SSC. And you send these 38, that same route, get it categorized through the appropriate authority. That you can do.
Just in another district, your lordship, the other day, Mr. Vaishya has submitted a report that it has been, they have sent and it has been categorized. Mr. Vaishya is over here, yes.
The same route, same route. This was the same,
And Bardhaman, same exercise.
same exercise. So you have to wait till it's categorized or something is done. Now he has been recommended already for the appointment.
Recommend
DI has appointed.
koi কত পাতা है?
Last election.
কই? কোথায় recommendation? No, not recommendation of SSC.
No,
PO
no.
as mentioned in the
What is
Swans
that record?
pension less than.
The DI has found him fit to, Mr. Basu Maulik, DI has found him fit to be appointed. Where is the document? Show.
Yes. The DI document will be appearing at page 55 of my writ petition, Your Lordship. The last annexure.
Remarks, my lord, total family income is less than the initial gross salary of the Group D staff at the material point of time. So the prayer of the candidate is considered for forwarding to so-and-so Eastern region for taking necessary action. Last.
Last annexure.
This was in 2021.
In 2021. And thereafter, no movement.
No, Shiva, I am a widow. I have been rendered literally penniless. All the expenses was.
When
incurred in-
your husband was a,
Yes, he was a cancer patient, died at a very young age.
when
Terminally,
died, when died?
he died in 2019, Your Lordship.
Yes. Can you
Stated that in
Date of death, my lord, 6/8/2018.
20.
Bappaditya Ghosh. This is
He was
employee.
a assistant teacher in the science group. Was diagnosed with stage 4 colon cancer, Your Lordship. Very young children, and the father-in-law is very old. They are cultivators. Small school going children, Your Lordship. Stated that in my report. I had applied in December 2019.
So the commission in its report submitted before this court,
Yes.
this
You kindly see page 6 of their. Para 4G. Indicated two criteria.
so unless commission receives properly rostered vacancy, they are not in a position to accommodate the petitioner or other
Suitable
candidates seeking compassionate appointment.
No, I would only beseech your lordship to take note of the fact of the precarious condition of the lady. Because most of my income was expended in treatment of my husband who died.
This is
at
the
a very
whole
young-
problem, you know.
died
If I dispose it today, it is a disposable case. Then I'm sure that she will be.
No, no.
she-
Let the matter remain before your lordship.
What is happening, you know, that is why the petitions cannot be disposed of unless it reach to the finality. This court is acting as not only the court itself, an executing court also.
Lordship.
দেখুন তো, the husband of the petitioner was an assistant teacher of a secondary or higher secondary,
Secondary school.
of a secondary school. He died at a very young age, leaving behind the petitioner only child
Yes. Yes.
and a child. Stop.
He has left behind a son and a daughter,
Oh, আজ কি লিখলাম?
12 years old and
Husband-
4 years.
Wait. না না, তার আগে লিখুন petitioner. Young age on August 6, 2018, leaving behind him surviving the petitioner, and two minor children. Two children. Stop. The petitioner applied for appointment on compassionate ground. Now, immediately after the death of the husband, the petitioner applied for appointment on compassionate ground. Stop. The district inspector of school is E. Birhum. The respondent number such and such. Birhum is respondent number? Respondent number 5. under his memo number 186G dated January 13, 2021, forwarded the prayer of the petitioner to the West Bengal Regional School Service Commission within bracket Eastern Region for taking necessary action. Stop. The matter did not proceed thereafter. Stop. This court directed the commission to file a report on the issue. Stop. The commission has filed such report. It appears from the said report that the commission has no rostered vacancy in its hand to accommodate the petitioner or other similar type of candidates seeking such appointment. Stop. Under such circumstances, the respondent number 5 was directed to file a report identifying the vacancies in Group C post under his jurisdiction. Mr. BASU Mollik, learned additional government pleader, files such report of the respondent number 5 bearing memo number 195/LS dated August 1, 2023. Let it be kept with the record. The report is enclosed with a list of vacancy statement of Group C staff in the within the jurisdiction of the respondent number 5. Stop. As it appears from the said list, from the report and the list annexed thereto, that there are 38 vacancies of Group C post in the said district, out of which only 6 vacancies have been are rostered vacancy, are duly being authenticated by the concerned department. Stop. The respondent number 5 is directed to send the said 6 vacancies. She will send it to directly or through commissioner?
No, 6 are vetted or that sent to the service commission.
Directly. Yes. To the how would we say it in shortly? To the school central, to the West Bengal Central School Service Commission within a week from date. The commission, on receipt of the said vacancy, shall consider the prayer of the petitioner for appointment in accordance with law. Stop. And shall file a report to this court on the next date of hearing. Stop. The respondent number 5 in the meantime shall take appropriate steps for authentication of the remaining 38 vacancies mentioned in the report, mentioned in his report. Stop. Matter be listed tell me a comfortable time. So within 7 days, you will be sending the 6 vacancies and expected by the 8th, you will be getting it. And
Already
you
handed
are
up this
required 7 days more.
এই তো এক্ষুনি পেলাম।
হ্যাঁ, না,
Then can we meet again on 21st or 22nd August?
My lord, let it be total 3 weeks. 2 weeks to the commission and 1 week for sending it.
বাকি দিন
Eight.
report কে?
Yes, it is coming on 22nd.
Yes, sir.
14 days, if you are expected to get it by 8th. You are expected to get it by 8th or 9th or 10th. Tell me.
Yes, if we get it by 8th, we can come back by 22nd.
22nd? 22nd.
ইয়াকে বলে দে, এটাকে immediate পাঠাতে।
One thing is clear that, yes, Mr. Counsel for the petitioner. It does not mean that 6 vacancies, even if it is found, it is otherwise ready to be accommodated to accommodate the candidate seeking such appointment. But your candidature, when it will come according to the list, then you will be getting. Then you have to wait. Then the 38 may come. Then you have to wait.
But we will come back with the report, but we will not exhaust the vacancies.
No, certainly. First of
After-
all, after
Yeah,
further
then
direction.
after
Wait for the further direction.
Actually, only one indulgence. May I get a copy of the report which has been filed by my learned senior friend today?
Is there any difficulty? Give it.
I'm grateful.
Dr. Patro, the another thing is that even if it is goes to you, supposing this total 38 vacancies, remaining 6 means remaining 38 or remaining 32. Not even a vacancy. Now, if these 38 vacancies are, would you kindly take this trouble, Dr. Patro, of at least to find out, do not include in your report that what are the number of candidates are waiting in the queue
Yes.
before you, recommended by DI and found they are eligible for such appointment in that district, or I don't know whether district wise or in the whole West Bengal it can be gone through. This is another confusion.
Well, I'll check it. It is done region wise, including
Then-
4 or
then-
5 districts,
Then
but the district preference is always given so that it can be near to the residents.
there may be some applications pending before you, which you cannot recommend for want of vacancies, rostered vacancies. Try to ascertain how many numbers are pending.
Yes.
Great. Question number 2.
My lord, I am appealing for the petitioner.
State.
My lord, this is also, my lord, the died in harness categories appointment of the petitioner. So for the father of the petitioners died in 7th September 2013. Thereafter, my lord, 14th February 2014, within that time, my lord, the petition has been applied for appointment for Group D or Group C. Now, ultimately, my lord, the teacher in charge of the concerned school has been referred to the DI of all the documents, and with a request to take actions. After that, my lord, 2013 September 2015, the concerned district of schools has been wrote a letter to the Commissioner of School Education
Where is that
for
letter?
further, my lord, for further instruction. There is page, my lord, 41. Page 40, P5. After that, my lord, the decision has been taken by the DI, referred to the, my lord, Commissioner of School Education. That is page annexer P7, page 42. The district inspector of schools, AC, is the competent authority to take a decision.
What he has written?
My lord, the DI returns to the Commissioner of School Education with reference to the subject noted above, that the name of the HON'BLE Besra, that is the petitioner, son of late Mohit Kumar Besra, assistant teachers of Jamtoria High School, applied for service in died in harness category for the post of Group C it is noted that the EEPF is rupees 13,620. That is the excess salary of Group D. Group D salary excess. That's why, but this, if the considerations of the diet enhanced category to be considered, only but in
Dr.
respect of
Patra,
the
don't leave.
excess
You are in
of-
the matter, I suppose.
This matter.
because the school service commissions were not long after referred to the school service commission by the DI.
No, School
But-
Service Commission is the party here.
Yes.
Chairman,
Well,
both,
Service
Chairman West Bengal School Service Commission,
yes,
this
yes.
point number
Is
7.
also, but this matter has been hanging or pending before the DI.
Why? He has written. to
Well,
the-
nothing has been done. Even that, after that, I have already
Show
got a
it,
letter.
show it to Dr. Patro. Page 41. What you will do with that?
Page 41 ওর হ্যাঁ বাবার স্যালারি ছিল কিন্তু এক্সেস
From DI to commissioner,
Yes.
with reference to the.
Run and from 2008.
Wait. What you will do?
It has not come to the commission. This.
No, what you will do? If the income of the applicant,
It will not reach the commission. The DI has sent it to the commissioner, he will reject it possibly. Due to excess.
oh, this
income.
is
It does
Commissioner of School Education.
education.
Sorry, I thought
And
that
he
it has
does not
traveled to you.
Qualify for the diet
No,
enhancement.
EPF is a considerable income. EPF or
No,
something.
no, sorry.
E-
This is employees provident fund.
EFT. Employees Provident Fund.
এটা কি লিখেছে? EFP.
ইএফপি
What is EFP?
এমপ্লয়িজ প্রভিডেন্ট ফান্ড
না, না,
তাই তো হয়
No, EFP.
EPF হলে
ইএফ না না
EPF or not?
EFP.
ইএফপি
What does it mean?
এমপ্লয়িজ প্রভিডেন্ট ফান্ড
But F stands for?
No, no, এটা স্টেটেড access.
আমি আপনি
No, no, no.
প্রভিডেন্ট তাহলে ইপিএফ হতো তো
Hmm.
না এটা ইএফপি দিয়েছে
What is this 13,620 you are getting every month?
Yes, my mother has been
This-
getting it. 13,620.
Well, possibly this is the family pension.
Enhanced family.
It is the family.
Oh, enhanced family pension. Oh, abbreviation, hats off. This is enhanced family pension is 13,000. Will it be counted to reckon the family income?
But I think so. One of the judgment of my lord, before the division bench, that 17,000 onwards, then there is no scope for it. I think so.
Family
But
pension will
No,
be
the
reckoned.
Candidate will be
Yes.
entitled to diet and to be considered for diet and harness if there is an
Group D.
income which exceeds the salary of a group D staff.
But
Now, family pension will be given to the candidate, which is 13,620, which is more than,
family
that.
pension will be reckoned.
yes, that is an income.
It
That
will
is the income.
come
So-
within this one. Then how can you expect
Yeah.
so?
This is the retardant benefit in respect of the deceased employee. Now the appointment should be considered.
Develop this point, show me,
Judgment are there.
show me the authority.
But
And this was in 2018 to the Commissioner of School Education. What happened thereafter?
But the DI is taking, is nothing to do.
thereafter the commissioner of school education has revert back to the DI
The DI is sitting tight over the matter till date. Even that application representation has been made out. Next page. 2018, then this petition has been filed by the next P8. September 2015.
Lordship- Lordship, DI has to take a reason order in this
Not reason order, just he is receiving, family is receiving a sum of rupees 13,620, which is more than the salary of a group D staff.
lordship.
That clarification, whether he is entitled to be listed at all or not, he sought, DI sought clarification from the Commissioner of School Education
Yes,
way back in 2018.
yes.
I thought it is from Commission. That is why Commission has no role to play in this
No,
case.
but commission has taken the decision that DI have to take the.
No, Commissioner, the
Yes.
Director of School Education.
This is the commissioner, yes, yes,
Director of School Education has reverted back to the,
to the
uh,
DI,
again to DI.
yes, for taking the for passing written order. Now, this is not only this criteria, they have to see that NOC from the other legal.
Other, very well, other formalities will be there. If his family income is more than income of a group D staff, he is not entitled to be considered even. Now, tell me whether the family pension will be included as the income of that family or not for the purpose of.
That is supporting the family, that is that to be.
Not so, this is the logic.
এটা- হ্যাঁ, portion of.
A portion, not the entire. Not the entire.
40% of the family pension.
Then 40% of this 13,000 comes around,
13.
less than
7,
4,000,
less than-
5,000 nearly, less than group D.
And other allowances, if there is any
And
other.
then you inquired in 2018, from there, last 4 years, you are pending this in that way. File a report from your DI. Huh? The petitioner. You are the widow daughter or the
Son,
unmarried.
Son,
son.
petitioners,
Himal Basera.
Himal Besra.
Petitioner is the son of a deceased assistant teacher. Assistant teacher of secondary or high secondary school, of a secondary school.
Jamtodia High School.
The petitioner complains that his prayer for compassionate appointment is pending consideration before the district inspector of school AC Purulia, the respondent number such and such, since 2018. Learned advocate for the state submit that he will take necessary steps and if necessary, he will instruction from the respondent number such and such regarding the grievance of the petitioner and shall file a report before this court on the next date of hearing.
Lordship. At least.
How much time you require?
At least 3 weeks time, Lordship.
3 weeks or 2 weeks? You do it by 2 weeks.
3 weeks. Purulia, we have to send it. to Purulia.
Purulia is very near. Matter be listed on such and such date. Report on the said date. 2 weeks. Did the
I am for the council lords.
council means?
The petitioner initially was a primary school teacher. He served there for about 13 years. Thereafter, my lord, through School Service Commission appointed to the post of assistant teacher in 2013. Continuing in one school in 2017. Thereafter, through mutual transfer to the present institution. The present case, if your lordship stands to page 42, because he is for my lord pay protection, fixation, as well as calculating the past service as under my lord primary school for the purpose of my lord making him eligible for pension and other benefit.
So first he joined in
As a primary school teacher in 2000, 17th of November 2000. He worked there till 10th of December 2013. Now on 11th of December 2013, as an assistant teacher of BIL Bidhan Chandra Shikhayotan.
assistant teacher.
Assistant teacher.
He participated in the selection process.
Service. He continued there till 14th of December 2017.
2017.
Then transferred to the present institution on 15th of December 2017 Until now, he's in service.
No, sir, therefore, you want to take benefit of your service as primary school
Primary.
teacher, right?
Yes. Proposal has already been sent to the DI at page 42 by the institution itself. Let the DI dispose it of.
Lord, say I am for the council, Lordship. But as my learned.
Council mean primary council,
Lordship, Purulia, District Primary School Council, Purulia.
who is for the state then?
State Lordship, that name, BISWAJIT, they Lordship, he is not in the panel, Lordship.
So then I have to serve and come back again.
If the Lordship director.
Bring someone because it is a DI to consider.
Yes, but I shall.
Already the school has sent its
Proposal to the DI.
proposal to the DI.
Yes.
If a DI direction has been to
Now
DI.
DI
it
has
to
Let the, in the presence of,
yes, yes.
not in the dark, let the
Lordship.
someone,
Keep it tomorrow so
Must
that
be.
I can bring.
yes, if you find somebody, get the name or otherwise I will engage somebody.
Great.
Not.
Five.
No, I'm for the petition. My lord, in this matter, my lord, I have prepared my lord supplementary affidavit, my lord, in this matter, my lord. My lord,
Let me understand the main one, then I will go
lots-
to the
lots-
supplementary.
lots. My lord, petitioner before your lordship initially appointed in a approved, in a recognized.
Yes, where is your report?
Report is here.
Thereafter, my lord.
Wait.
আমাকে না দিতে বললে দিতে পারবো না তো। Let a copy be.
Now, your complaint, first of all, you first joined at
Yes, Vidyaniketan. In the year, my lord, 1984.
from 14/11/84
Lordship.
on 14/11/84 and then resigned on 28th June 1989.
Lordship.
This was an approved service.
Lordship.
Then you will join another unaided school.
Unaided school, but my lord, recognized approved school. It's a recognized institution.
Unaided school from 89 to 97.
My lord, one thing, my lord, recognized
And their
But
salary,
your salary was not sanctioned by the department, education department. Your salary was not sanctioned. Last pay of Vivekananda, that was the ROPAR 90 done. Then you have become the headmaster of the second school, NTPC High School. Because you was eligible as headmaster, eligibility not questioned.
NTPC,
But pay protection was not approved.
my lord, pay protection was, my lord, approved by the concerned district inspector school when I have appointed as a headmaster of a Raiganj Coronation High School, my lord. And
This is
on
your
the
third
basis-
school.
that is, my lord, approved school, approved, recognized, aided school.
How many schools you have served?
My lord, three. First, SGS, my lord, approved, aided school. Thereafter, my lord, approved, recognized, unaided school. Thereafter, approved, recognized, aided school. As a headmaster, and my lord, when I have appointed as a headmaster of the last school, that is Raiganj Coronation High School, my appointment as a headmaster was approved, and my salary was fixed from the scale of pay. That is the last pay of scale of the NTPC school, my lord. Their salaries are same as it is, my lord, the approved aided school.
Now, your grievance is that your whole pensionary benefit has not been
Not
given.
given, and my lord, they have according since, my lord, in the in mid portion, my lord, I have served in a school which is, my lord, approved, recognized school. Their salaries are same as of, my lord, aided school. But
What
according
kind
to
of
the-
report you are filing?
My lord.
Why he is not entitled to? You have supplied some facts.
Yes, my lord.
Fact will not do.
My lord,
One-
please to direct me to submit a report, not affidavit in opposition.
No, report means that I want to know why. Why you are not allowing his entire retirement benefits?
At paragraph 6, I find, my lord,
Uh,
Malda, that is the NTPC High School, did not approve him as an assistant teacher, NTPC High School.
Full pension, other retirement. You are withholding his full pension. You are not getting pension at all.
pension I'm getting, my lord, lower scale, my lord, according to them, my lord, my salaries was, my lord, not fixed on the as a continuous service, and my lord, they are, according to them, my lord, that
Just tell me how you have justified your action from your report. Read out which portion you want to read.
My lord, paragraph 6, my lord. Approval of joining of assistant teacher of SGS Vidyanikandar has been approved by the district inspector of school SE and South Chowbis Pargana, and headmaster of Raiganj Coronation High School approved by the district inspector of school SE Uttar Dinajpur, district inspector of school SE. Malda did not approve him. Malda, where he was in the service of NTPC school, Malda did not approve him as an assistant teacher NTPC High School.
Then what is the
And my lord,
conclusion?
another thing is, my lord, I do not know,
You are the pension sanctioning authority.
my lord.
You are not inclined to pay him the full pension as he is claiming. Where is the justification? You must disclose that this is the reason for which I am not
lord.
granting him the full pension. The report is about you are dropping some information to this court.
My lord.
I do not want your information, your justification.
Yes, my lord. And one thing, my lord, I do not know, my lord, whether it is it will be helpful for that or not. My lord, overdrawal has been done. Overdrawal has been done according to his affidavit.
He agreed.
My lord.
He agreed. Take it from the gratuity amount.
Yes, my lord.
And accordingly, gratuity amount clear. If this report is nothing,
My lord, I'm asking the
make it very clear that this is
Why
the
he-
reason for which he is not entitled to full pension and retirement. The advocate for the petitioner prays leave to file a supplementary affidavit to the petition. Leave as prayed for is granted. The supplementary affidavit is taken on record and be treated as a part of the writ petition. Stop. File it. Copy be served upon the learned advocate, the appearing respondents. Stop.
ওখানে order record
The report as directed by the order dated July 2023 is filed. Let it be kept with the record. আচ্ছা, reported detailটা bracket এ দিয়ে দেবে। Report as directed by the Auditor General is filed on behalf of the respondent, on behalf of the District Inspector of School AC Uttar Dinajpur, the respondent number 5 hearing bearing memo number such and such, dated such and such, let it be kept with the record. This report is not complete. The said respondent is directed to file a further report justifying his action not to disburse the full pension and other retirement benefits to the petitioner. Such report be filed on the adjourned date. Matter to appear in the list. After a week,
2 weeks, my lord. 2 weeks, my lord.
already you have prepared. Very well. 17th August.
Well, a copy of the report, we let a copy of
This
this.
is the
It's incomplete report. Complete
Incomplete.
report you will be getting.
Well, I already have the supplementary to my plan.
Next.
Good.
Number 6.
Lordship appearing on behalf of the state respondents.
For the petition. A convicted teacher is before lordship. Convicted teacher. He worked since 1998 to 2014. 2014 life imprisonment in the month of July. Preferred appeal, criminal appeal before this honorable court. Appeal has been admitted, that is pending. In the month of December, he has been, the sentence has been suspended. Now he applied before the authority, allow me to resume my duty, that was denied. In the meantime, in 2016, he attained the age of superannuation. Now he has been being paid only the provisional pension in terms of law. Now at present, he is at about 67. The criminal case for which he was convicted, that was not related to this service or related matters.
What was the nature of criminal case?
302. 302 life imprisonment. Now, why I am before lordship, I request my learned friend to go through a particular judgment, a recent judgment passed by my Lord Justice Aniruddha Rai, coordinate bench, and to come back on the next day so that my lord we can.
What is your prayer? The release of full pension?
Yes, ma'am. আরেকটা আছে copy. কি করে এগুলো তো back to
What is the impugn order?
impugn order here that we have prayed for enhancement. They said it's not possible, page 47. They said it's not possible, but I find that in terms of law, as was there, the order is correct. But due to change view of this court, my lord, আনতে বলো না কপিটা করছি বলো জাজমেন্ট কপি দিয়েছো কেন? Or kindly pardon me, I have a copy, but it's both side printed. That's why I'm in hesitation.
You are banking upon that only.
It's that only. Because here, my lord, this judicial proceeding or criminal proceeding that has been explained in a way that if it's not relates to the service benefit should not be withheld. I'm sorry, my lord, I have a fresh copy, kindly. Or I have a fresh copy, my lord, kindly take this one.
Yes, show me 19.5.
বইগুলো দাও আমাকে। হেডমাস্টার ম্যানুয়াল আছে? Education.
BCRB scheme. Hey. Flagged one, flagged. Headmaster manual, yes. Headmaster manual.
Pension বের করো, pension বের করো।
It's a flagged one, I suppose that. Yesterday I dealt with it.
Yes, yes, ma'am. Fine. 19.5, your lordship. It.
Yesterday I disposed of one matter where a retired head teacher's right to get the full pension has been challenged by another assistant teacher on the ground that he has filed 2 complaint cases against this headmaster. Maybe some rivalry was in. I dismissed this with the cost of rupees 50,000, not in the tenor of that I have already held, that the proceeding must have some nexus with the interest of the school or the infraction of any of the rules. If a criminal case is initiated by a third party, by the neighbor even, against the teacher, pendency of that criminal case will disentitle him to get the full pension. It depends. If the conscience of the court pricks, supposing the nature of allegation is such, you understand what I mean?
Yes.
Then the question may be, but my prima facie view is this should be the approach. Now, it is like say the 302.
And life conviction is there.
We'll go through it. Interpret this judicial proceeding, departmental / judicial / proceeding. What is the scope of this interpretation of this 19.5? Is it so wide to include any kind of, supposing 144 is pending, 107 is pending. Any authority you are getting except this on the interpretation of?
Madam, let us come back next day so that I can.
You find out.
Sure. I shall come back on the next.
I'm keeping this.
Or can I keep this one? This is fresh copy.
It is body level. It was 1920. Place it on 17th August.
Great.
Much obliged, Lordship.
Number 7. This one run. This matter
relates to withholding of pension on wrong fixation. Due to wrong fixation, Lordship will find the observation
When you retired from your service?
I retired on 31st October, 2021.
Yes, your pension paper reached up to which stage?
My lord, actually, I made an application for getting pension under the prescribed format, but nothing has been done. Thereafter, I find from Lordship kindly come at annexure P9, that is annexure P9 page.
অনেক টাকা
P9,
720
39 before your
আর 110 830 should be
So online.
27 place.
to online, I received this observation of the concerned authority. The pay of headmaster of higher secondary school.
You are the headmaster,
Yes, I am the headmaster, headmistress.
headmistress.
Pay of headmistress of higher secondary school upgraded after 27 February 2009 needs to be reviewed and re-examined in term of GO number 292 such and such, dated 23rd March
Date কত date?
2017.
1/9/2025
Pay on, very important, my lord, pay on 1st September 2009 should be 27,890 in place of rupees 28,720. My lord, rightly or wrongly, what they have fixed after retirement, they are going to recover it.
No, that is not permissible, everyone knows that. But there is a wrong pay fixation, that is only the cause for not disbursing.
Only because Lordship kindly asked my learned friend to.
So, Mr. Boisho,
Lords,
ask the pension sanctioning authority to clarify.
no lords, here lords DI first, lords DI district inspector is pension sanction authority, not for the. I asked whether the director do the pay, submit a report, lordship. On the basis of the report, lordship, this is better.
Yeah, sure.
But here, lordship, I am only praying before his lordship every time. This court I am praying, lordship. When the ROPA come, lordship, within 5 years, that lordship, that types of case has been lordship audited. Lordship, I am only praying. That type of case
Why?
is audited on the 5 year.
But no, nothing, no one noticed it. No one noticed. It was intentional or something.
Lordship, it is intentional. The district inspector, school headmaster, total get of
One must be knowing that this is the pay revision and she
But
is
lordship,
having
when the lordship ROPA rules come, ROPA come every 5 years, that 5 years lordship only for the audit, only for the school audit that. That lordship circular by
at the time of audit, it should have been detected
lordship.
that there is a wrong pay fixation for
Lordship,
some
when the
teachers.
audit has been done, lordship, that's already some of the fixes or wrong fixes.
This is really astonishing why the school authority or the auditor did not notice that some teachers are getting higher amount of pay scale, they are not entitled to according to the
Lordship, but
relevant
lordship,
ROPA.
without audit, lordship, this is the principal
This was-
director of the principal secretary to do this, lordship. If the lordship direction, lordship, that is do, lordship. Kindly, lordship.
No, the petitioner was the headmistress, Jhilimili High School.
No, my lord. Subsequently, I
On school day.
Lordship will find from
Rajagram.
Lordship.
The petitioner was the headmistress of Rajagram
Audit হলে তো
Girls High School within bracket HS, district Bankura.
ওটা audit করলেই তো হবে, without audit তো হবে না।
She has retired on superannuation. She has retired from his said service on October 31, 2021. Stop. The petitioner is complaining delay in disbursement of her retirement benefits. Stop. Mr. Boisho, learned additional government leader submits that he will inquire into the matter and shall file a report from the pension sanctioning authority, report of the pensioning sanctioning authority on the next date of hearing. Matter to appear in the list 2 weeks. 17th August, to date report,
Lots, I am grateful.
Grateful.
to date for filing report.
I'm grateful.
Well, on behalf of Mr. Sarwat Chan, a short password maybe on matter
Pass
called
over.
grateful man.
Nine, my lord, I am appearing for the state, my lord.
For the petitioner in this matter.
Lord, I am submitting the report, my lord.
কপি দেবে?
আপনাকে স্যার পাঠিয়ে দিচ্ছি, একটা কপি আছে।
You have obtained the signature of the petitioner.
My lord, he did not come, sign, my lord. It was annexed, my lord,
He did not sign means,
petitioner, my lord.
oh, without consulting the lawyer.
Yes, my lord. School
Have you
authority
instructed-
went to his office.
See what is there in the report.
File has already sent to the DPPG, my lord, in the gratuity for the gratuity part, my lord.
But without signature, you cannot. do
But
that.
since there is an order for the compliance, my
sent
lord,
it.
we have sent, my lord.
LWP means,
My lord, LWP, that is, my lord, leave without pay.
oh,
And another is extraordinary leave, EOL. Sir?
Oh, thank you.
সাবমিট করছে ওরা যেটা করেনি সেটা শুধু সাবমিট করছে, আপনারা লিখে নিয়েছিলেন, এটা আমি দিয়েছি।
the petitioner's claim has now come to only gratuity.
Yes, my lord. Only gratuity part.
No, my prayer is also for pension.
No, prayer, you are not under the CPF scheme. You are under the CPF scheme.
I shall come to that. Let him complete his episode of submission.
No, this is a report he is submitting. My earlier order was, the report suggests that the petitioner was under CPF scheme.
I was in CPF scheme. It was diluted in 1990. Automatically, it's statutory dilution.
Automatically,
Yes, that is the law.
you will come under without
Automatic. Whoever is opting for, that has been held by the division bench also.
opting for, you need not, never opted
I don't
for.
require to opt for further. After 1990 ROPA, there was no provision for option. Option was completed in 80-81 scheme, 1985. But there was no question of further option. Whoever is opting, rightly or wrongly, they will be entitled
Is
to
it
the
your
pension.
petition's case?
That is the pension I have paid.
No, have you stated that you need not file a, and you use your affidavit then? If you have a case,
Look at one.
no, I will do first foundation in the pleadings. You show what you have prayed for.
I have prayed for my all retail dues.
Yes.
And my prayer is for pension. And you look at the prayer.
Yes. Are you suggesting, where have you stated that you are in sub CPF scheme, you have, after this,
Para 10.
no, 9 you have said?
Yes, I opted under ROPA 1990. 17 to his pleading is there.
That you have stated that you had exercised option.
And will entitle to revised scale and the pensionary benefit.
How it have, you have opted for such? How you
That
have?
is not required after ROPA 1990.
No, kindly come to the paragraph 9 you have stated.
The teaching and non-teaching employee aided and sponsored education.
So that you have stated that you petitioner had exercised an option.
Petitioner exercise option to come under the revised pay
Kindly
1990.
show how you have exercised.
1990 ROPA benefit has been given to me.
No, I don't follow. You have stated I had exercised an option to come under new. How?
I have been given ROPA 1990 benefit. Let them produce the records to your lordship. I am absolutely without record because I was from 1996 onwards, I could not go to school and I was a saint, was out of the world.
No, understood, but you have stated very clearly, I had exercised option.
I had exercise option under ROPA 1990. Under ROPA
No, this
1990.
is, sentence is complete here. As per the teaching and non-teaching employee aided and or who will opt the revised scale of pay shall
That is
be allowed
first
to
sentence,
enjoy.
first sentence is ROPA 1990. First sentence, second sentence. ROPA 1990.
Sir, that you have interpreted Nota 90 as per this. Whoever the teaching and non-teaching employees of aided and who will opt the revised scale of pay.
Yes. I opted for revised scale of
That
pay.
is what I want to know from you.
I
How
have
you
been
have.
given the revised scale of pay.
Are you suggesting that since you have been given revised pay scale,
Without I seek for the same money, they don't give
you
it.
don't have any?
I may retain my old scale. I may also retain my
Sir,
old scale.
Bhattacharyya, are you suggesting that giving you the benefit of ROPA 1990 signifies?
Presupposes
signals-
existence of an option. Presupposes. That is not required to be proved by me. Presupposes existence of an option.
You use your affidavit, if that be the case.
Man, I shall use it.
Use your affidavit.
And provident fund, those have been paid, let them give an
No, you are
expenditure.
not willing to put your signature even to get your gratuity. What they can do?
Don't ask me, that let him say.
I have annexed, my lord.
No,
Signature without consulting lawyer. Yes, Ashun. The report as directed by the order dated July 18, 2023 is filed on behalf of the respondent number.
I am for the state authority.
No, report of whose report is this?
Yeah.
Respondent number
Respondent number, my lord,
on behalf of Sajan, sir, let it be kept with the record.
6.
Acha,
6.
to decide the issue under consideration. Affidavit is necessary without inviting affidavit from the respondents. The issue under- the issue under consider cannot. be
Judge order
decided.
Judge order আছে আমি কি করব? পাঠিয়ে দিচ্ছি।
Calculation তো করো।
3-2-1,
I shall.
matter to appear 6 weeks for hearing.
আপনি এটা এভিডেভিটটা বলে দিন যেটা বলছেন 3-2-1 3 সপ্তাহ অপোজিশন 1 সপ্তাহ রিপ্লাই 4 সপ্তাহ বাদে
No, 3-2,
3-2-1 মানে 4 উইকস আফটার আসবে
you are very weak in mathematics. 3-2-1.
3-2-5-1 as is not
Weak in counting, not in weak in counting,
all round
counting in money, but counting in mathematics. Next,
And in this matter, I am for the petitioner. This is relating to the pension from the date of retirement to I have also to date of giving my pension on the basis of refund my employer share. It is covered by my lord judgment. This is
who is for the state?
I have affidavit service.
Overdrawal.
No, no, no,
Is a case of overdrawal.
no. My lord, the pension was given from the option was made by me from CPF to GPF. And
So
pension,
the date, from the date of returning money, you are say from date of retirement. That you are, your
Yes,
prayer
yes.
is
date of
release
retirement.
area pension between this period.
Yes, my.
Where, when you have refunded your money under the TR form number 7. Have you corrected the order?
Yes, yes, I have corrected.
Just stop. Next.
পরেরটা এই যে অর্ডার affidavit
CPF to GP.
Why are you so late? 2008.
Fourteen, I have the state in the front.
My lord, kindly make it password, my lord. Mr. Sarabaj John is engaged on code number 5, my lord.
Password.
So,
15. Lord, I am putting.
Where is the decision?
Page 44. The petitioner 100% blind. 100% blind. His elder sister also, my lord, the 100% blind. Father, mother, blind. The father was the assistant teacher of the school. After his death, his mother was getting pension. The retired on 31st April 1981. DCRB scheme effect from 1st April, just one day before. That is why the pension was not sanctioned. But after 15 June 1990, government clarified that who retired prior to 1981, also you will get pension. Subsequently, another notification was issued, just the shortcut, page 47, amending the DCRB scheme that the pension as well as the family pension to be extended to the widow of the pensioner.
Even if died prior to
Prior to 98. The only widow. The other disabled, the disabled child and the widow daughter, unmarried daughter, they are not getting pension. The Honorable Justice Dipankar Datta delivered a judgment, no. Since the circular is there, except widow, nobody can. Another division bench judgment contradictory. Ultimately, matter going to the larger bench.
Recent larger bench.
Larger bench they held that to all. So now, as per the larger bench decisions, the disabled child is entitled to the obviously this impugn order has been passed prior to the decision of the larger.
So in view of this decision,
In view
the
of the
situation,
decisions, I submit before your lordships, let them take an instruction. Well, because
no, this is it. This is a son,
but
blind son,
100% blind son. And
seeking
both
the family pension.
family pension. Both of them, my lord, they are living.
Initial instruction, my lord, that commissioner has taken the decision since the concerned, the relevant government order, that is 10 ACB, that is, my lord, applicable for the retired employees who are guided by the DCRB 81. Now, since his father has already retired prior to that date,
Will not be
it
applicable.
not be applicable.
But subsequently, widow was included, as I have understood from Mr. Jana.
Yes, I have an annex PPO.
Then the widow is restricted to widow only.
Widow.
Now, after the special bench judgment, it has been extended to the
Special bench judgment lordship not applicable to the disabled child lordship. Only for the married and lordship widow. Widow daughter, not for the lordship disabled child.
It cannot extend it.
Only for the two, only for the widow and lordship unmarried daughter.
Unmarried daughters.
But nothing to anything.
Providing
Lordship,
pension,
real lordship,
providing pension to living employees or their widows, in our view, cannot restrict the beneficial provisions contained in the memorandum as above.
but
To
lordship,
the living employees And your lordship circular say, your lordship kindly see circular, as per circular he is claiming for pension. That I have annexed, my lord, the page 51. Page 51, relying that they have rejected my claim.
51, right?
Page 51.
Uh,
That is the family pension extended to the children
It's
suffering
even
disability.
after 480.
Paragraph 3.
আমাদের হচ্ছে প্রায়
Only the disabled child whose family are in receipt of pension, family pension under GO number, that is DCRB scheme, will be eligible. Family was getting pension.
no,
So why are you banking on the special bench judgment?
no.
You need
He's-
not travel to the bench.
Yes,
Lot,
that is
if you are
also-
banking on this 13 January 2009 memorandum, which says only disabled children whose family are in receipt of pension, family pension under GO number Sanjay will be eligible under this memorandum.
After 1481 lordship, kindly see,
After
not
before that,
prior.
that is not the-
No, kindly see the
Wait,
lordship.
let me understand.
Lordship, prior, no, after 1481. Here, Lord, এই তো দেখো না, who retired after 4/1/1981? That GO. Here, lordship, prior
This
to
GO you are referring to.
what lordship, here, lordship? 136 Eden beat 15/5/51. And as a result, the disabled children as
No,
such.
he is referring to memorandum dated 13th January 2009,
13 January 2009, lordship.
paragraph 3,
Paragraph, I am saying to paragraph 1, lordship.
1.
Paragraph 1, the GO 136, 15/5/85, and the result, the disabled children of such employee who retired after 1 March 1981.
Then
That he
But-
retired,
but-
lordship, prior to 1981. But he retired, kindly see the my lordship, Commissioner of Education, paragraph lordship 7, page lordship 45. After the lordship director to consider the representation, lordship page 44, inner page 45. Paragraph 7, paragraph lordship 7. As per the certificate issued by the superintendent, Baruipur HD Hospital, bite number such and such, Jyoti Prakash Chatterjee has been certified to be suffering for 100%. Lordship, I am real, lordship, 100%. But Lord, in his letter, lordship, paragraph 9.
No, which page, tell me.
Page 45, lordship.
Page 45,
That the Commissioner of Education passed order.
yes.
Page 45, paragraph 9.
Hmm.
However, the provision of the memorandum of, lordship, got it, lordship. School Education Department, West Bengal, bite number 325, read with 10 SE dated such and such, clearly specify that only the disabled children whose families are in receipt of the pension family person under GO number such and such, those employees who were in active service on or after 1/4/1981.
yes, I was getting pension.
Getting pension, but lordship, prior to.
No, on or after.
Mr. Jana, the paragraph 3 of this memorandum of 13 January 2000 says only disabled children, family members in respect of family pension under GO number 136.
136.
Dated 15/5/85 will be, you were getting prior to that, paragraph 1. Who exercises option in pension, including family pension, which is introduced with effect from 1/4/85 GO numbers, and as a result, disabled children of such employees who retired on 1 but prior to 5/9/2005.
I don't know.
After 81,
Yes,
are you getting it at paragraph 1?
paragraph 1.
And prior to 5th September 2005 were made eligible for life payment of family pension under such and such.
That is the, the facts has been stated.
He retired
Not
from
a-
the service
not a
31st
paragraph.
March 1981. The petitioner father is retired from the 31st March 1981.
Just one day before this.
Let's say, I am totally.
No, very well.
I
Very
am
well.
totally
Understood.
sympathetic, lordship, but my lordship,
Paragraph 22, I moved earlier it petition. And my lord, when the widow was denied by the family pension.
That lordship, I am
passed-
nothing to say anything.
They passed a reason order, page 22.
Page
22.
22.
This is the moved, my lord, widow moved the writ petition. Now widow died. That is the reason order passed by the Commissioner of School Education, page 23, penultimate paragraph. However, upon detailed consideration of the issue of granting family pension to the widows of those teachers and non-teaching employees of the secondary school who died while in service or retired from service before 1481, under the scheme of the government has issued GO number so and so 1st November 20, GO 1st November 2010, that I am coming. In accordance with the said government order, I direct the DI to take necessary action for sanctioning family pension in
Therefore,
favor of the petitioner.
this 1st April 81 date was made flexible, relying on this 1st November 2010 GO. Made applicable to the widow.
Widow. My lord, I just made.
Widow lots.
My lord, thereafter, my lord, in pursuance of this region order, my lord, the PPO has been issued. Family pension widow was getting. Now the 1st November 2010, only pensionary benefit is extended to the widow. Now that 1st November 2010 has been considered by the larger bench. Why, my lord, the first, my lord, the only widow? Your lordship
Go there.
consider the entire judgment. Why, my lord, the only, my lord, the widow?
It is extended to the daughter.
Yes.
Not only daughter, my lord,
Unmarried.
Read out.
because there are several government orders, family pension extended to the daughter, widow daughter, unmarried daughter, and also disabled children. But the larger bench considered that not only, my lord, the widow, that has been considered, my lord, the extended the benefit to all.
All means?
All means.
Yes, all, your lordship kindly see. That is the, my lord, the spirit of the judgment, my lord, the subject to correction, your lordship kindly see.
All means. Mislead করছে লট টোটালি
Mislead
মিসলিড
কেন
করে
my lord, একটা কপি দিয়ে দিন। Lord, the last 2 page, you'll also kindly see. Or the second last paragraph. From the memoranda as above, it is clearly explained that the legislative intent was to extend the benefit of family pension to unmarried, widowed, divorced daughter of an employee who retired before or after 1481, or to unmarried, widow or divorced daughter of a family pensioner. In such premise, the memorandum dated 1st November 2010 should not stand in the way of extending such benefit in absence of any express provisions therein, restricting or affecting the benefits, socio-economic justice stemming from the concept of social morality, if pressed into service. The memoranda granting social security of livelihood to the aforesaid sieges of women by providing family pension should be construed liberally. Some isolated terms in the memorandum dated 1st November 2010, providing pension to living employees or their widows, in our view, cannot restrict the beneficial provisions contained in the memorandum as above. Therefore, we answer the reference to the extent that the benefit of family pension can be extended to the unmarried widow daughter of an employee. My lord,
Extended to widow.
although, my lord, only the circular extending the benefit to unmarried and widow daughter has been considered, but their lordships, my lord, was of the view that the pension of living employees,
not mentioned here.
that is the, my lord, the only, but this 51, which you I am referring, my lord, I am entitled 51. I don't, my lord, only the disabled children whose family are in receipt of pension. My lord,
133
they have extended the pension, family
হ্যাঁ এই
pension.
তো 10 দিয়ে করেছে
Either before 81 or after 81. Well, they have extended as per, my lord, the Commissioner of School Education. Family pension was getting, my lord, the widow.
148
My lord, the TCRG scheme amended 15 June 1990. Thereafter, 1st November 2010, Thereafter, several GO has been issued to the in favor of widow daughter, in favor of unmarried daughter, in favor of disabled
Are
children.
are you suggesting that paragraph 1, the apparent anomaly in between paragraph 1 and paragraph 3?
Paragraph 1, Melody, once again, I may read it. The undersign is directed to say that terms of memo dated 325 ACB and so dated 5th September 2005. Family pension for life is payable to children suffering from any disorder or disability of mind or who are so physically crippled and disabled so as to render them unfit to earn a living even after attaining the age of 25 years, subject to fulfillment of certain conditions. Benefit of family pension for the employees of the recognized non-government aided educational institution who exercise option for pension, including family pension cum gratuity, was introduced with effect from 1st April 1981. GO numbers, that is DCRB scheme. As a result, the disabled children of such employee who retired after 1481 but prior to 5/9/2005 were made ineligible for lifetime. That is the observation for up to 25 or lifetime. That is the clarification after 1481 disabled.
But it stands in contradiction with paragraph 3.
Paragraph 3. 3 says, who are received of pension, family pension. Widow was getting family pension, either pre-81 case or after pre-81 case.
How do you interpret what was the necessity if the intention was to give this facility, the facility or this kind of relief to all of the children, disabled children of the employee, then why in the paragraph 1 this has been quoted that this should be
Paragraph 1, where the benefit of family pension
reconcile this paragraph
after
1 and
attaining the age of 25 years.
no, last, as a result, the disabled children of such employee who retired. Why this? This is that this qualification or restriction is absent in paragraph 3.
Paragraph 3. That is the.
How can you reconcile with 3 and 1?
Lord,
That Lord 3 puts an restriction who retired prior to 1981. First
And
April.
the second paragraph, notwithstanding anything contained in memo number 325 dated 5/9/2005, the governor has been pleased to decide that disabled children of those employees as defined in para above who retired after 1481 but prior to 5/9/2005 will also be eligible for grant of lifetime payment of family pension irrespective of the fact as to whether such children acquired disability before or after retirement of death in harness of the employee and or such children were born of a marriage solemnized after the retirement of the employee, provided this is the melody.
Yes, I am not objection.
Then why this dilution in paragraph 3? Paragraph 1 and paragraph 2 puts a restriction on the date of retirement. But paragraph 3 is as if whoever is receiving family pension under this GO, their children, disabled children, are entitled to family pension. Mr. Jana, you have to interpret it.
Not only this government order, my lord, consider that since the government has taken a decision to extend the benefit of family pension to all,
Only the disabled child.
by one circular disability before 148.
136.
By one circular, my lord, the widow daughter, unmarried daughter before 148.
Will be eligible.
Now the larger way said that only to the widow or unmarried daughter, not only that.
This is one interpretation of yours, one way of looking into this. But the GO on which memorandum on which you are relying, there is apparently, prima facie, apparently there is a contradiction between paragraph 1, 2, and 3. 3 dilutes everything. What is there in the 1 and 2? 1 and 2 says prior to 1481. Paragraph 2 says between 1, but prior to, after 1481, but before 5th September 2005. Paragraph 3 says that who is getting. There are 3 situations contemplated. 3 situations, different situations. 1, paragraph 1, employee who retired prior to after 1st April 81. Then paragraph 2, 1st April 81 after but before 5th September 2005. Third, those who are getting family pension under this 136 hidden.
136 lordship prior to 1481. 136 circular.
So these are the three.
Lordship, I am
situation has been
lordship,
contemplated.
136 circular is
Now,
prior to
widow was
1481.
getting pension under 136 hidden.
Let's.
160.
So why the disabled child,
136 only.
if this disabled child of that widow comes under paragraph 3, then paragraph 1 will be diluted. There is no meaning of paragraph 1.
Paragraph 3 lordship applicable the 136 prior to lordship 1490.
Then you are reading it in conjunction. That you are first answer it. These two paragraphs are independent or dependent?
Lordship, that lordship, if the lordship require lordship, I am satisfied before it lordship. Lordship, if the
It is
lordship, if the
independent. These three paragraphs are independent.
Lordship, I
This
am
is
only.
last.
Lordship, I am
The
totally
last
simple.
way
It's
is
a
coming.
blind lordship. It's a total blind.
No, this
But
third,
lordship,
Mr. Jana, just interpret it whether this paragraph three paragraph stands independently
lordship.
or it depends upon each other.
That paragraph on page 51.
136
Does
previous government order page 50.
136
This is the
no, Mr. Jana, does this paragraph 3 is dependent on paragraph 1 or paragraph 2, or it can be read in isolation of paragraph 1 and 2?
Let's say if
If it is can be read in isolation in 1 and 2, then 3 is that whoever is getting family pension
that is applicable.
under GO number such as 136, any disabled child of that pensioner will get it. Now, if you go by 1, then the restriction comes 1st April 81. There is another problem. Now, your client got the pension, family pension, on relaxation of this 1481 circular. Well, he was getting.
That is no problem.
Does it mean that this is a situation is likely to be covered by paragraph 3, like your situation, where the widow, to give widow the family pension, the restriction of 1481 was relaxed? Please think it in that way. If the already relaxation has been given to the widow, already given to the widow, why not paragraph 3 will come to serve the disabled dependent of this widow? It is a pure question of interpretation. Mr. Boisho, you think about also that in that way.
Lots.
I'm posting it after 2 weeks for hearing.
Lots.
Affidavit is not necessary.
Not necessary, lots.
Next week.
2 weeks, lots.
Next week, I have some personal problem.
Anyway, 2 weeks.
So,
2 weeks left.
17th August. 17th August. Come prepare with all these relevant government orders.
Lots.
My only requirement, my only query from you is whether you can read this last GO referred to.
I understand.
3 paragraphs independently.
But give me all. Let's say I am coming.
No, I'll order these up. Okay, ওই জন্য হচ্ছে 17 লিখে তো লিখলে সুবিধা আছে।
Get to them.
Appearing on behalf of the petitioner. I'm filing my affidavit of service. Petitioner before your lordship, petitioner number 1 is the son of the deceased teacher, and petitioner number 2 to 5 is the grandson and granddaughter of my lord, predecessor daughter of the deceased teacher mother. Petitioner, the original beneficiary, my lord, the teacher retired on 24th March 1990, and he died, my lord, sometime on 25th May 2001. Malad, neither during his lifetime nor after his death, he has got his retirement benefit. Malad, the petitioners have filed a writ petition before this honorable court, and Honorable Justice Dipankar Dotto was pleased to pass an order. Malad, kindly come to page 47.
Page?
Page 47. Relevant page at page 49. In view of such matter, the court directs the Director of Pension, Provident Fund and Group Insurance West Bengal to immediately decide the claim for retirement benefits upon granting opportunity of hearing to all the legal heirs of Pratindranath Maiti, the school and the other interested person, if any.
Where is the order impugned?
It is not order impugned, but on page 47, Justice Dotto was pleased to direct them.
Then something has been said by their authority.
Malad, nothing has been said. Malad, in the meantime, that writ petition has been dismissed for default. I only want the implementation of the order passed by Justice Dotto.
Dismissed for default.
Yes, Malad, this part had matter. All on a sudden, the matter has come, and the erstwhile advocate did not has oversighted the same. Malad, page 64. It has come under the heading old matters, and the school authority, while disclosing the, kindly see, the school authority will also mention and indicate the total amount on which they.
This is the original teacher applied for prime
Yes,
pension.
and thereafter.
He did
Malad,
not, he did not get.
He did not get. And as Malad, no step has been taken. Thereafter, the legal heirs of the petition has filed the.
In his
petition.
lifetime, he did not get it.
Yes, Malad, in
Though the
lifetime.
court has directed that
It is the
for the
last
date
order.
commissioner, after getting the papers of the director of issue pension payment order.
Yes.
Nothing done.
Nothing has been done. Thereafter.
Thereafter, the second writ petition by the heirs of the deceased teacher.
Yes.
Now this was an interim direction to the Director of Pension Provident Fund Group
Authority.
Insurance
To
to decide the
hearing
claim
the
of
party
after
and
giving.
actors. Nothing
This
has
was
been done.
passed in the year 2010. This
nothing-
order must have been communicated to the Director of Pension Payment.
Yes, yes.
What he has done so far.
They have done nothing.
As per the instruction, I have received instruction from the
No reasoned order as it
Nothing has been taken. No decision has been taken.
asks the DPPG what this order was communicated to him. Either he may plead that it was never communicated to him, or it was communicated what steps he took rather during this from last 12 years, what he is doing with this order of the court.
second thing, my lord, the petitioners, grandchildren, whether grandchildren are eligible to get the pensionary benefit.
Section 8 of the Malad.
What is the pensionary benefit? This is whatever he is not claiming. They are claiming that family pension, employment, nothing. Whatever dues are there, the monies which are lying of their father with the government, pay it back to us.
Yes.
What is the difficulty? An amount payable to their grandfather,
Grandfather. Well, predecessor.
paternal grandfather.
Where the son is alive, the son is alive.
Son as well as the
Son is,
Where?
yes.
What about the
Section 8.
succession?
Section 8 of the Hindu succession.
They are the Hindus.
Yes,
In the
yes.
death of, they are the class 1 heirs along with the son. The son, daughter of the predeceased daughter. You take instruction from the DPPG. Respondent number?
DPP respondent number. Uh,
3.
3.
Ashun. Evidence of service filed on behalf of the petitioner be kept with the record. The petitioners are the heirs and legal representatives of a deceased assistant teacher of a secondary or higher secondary school.
High secondary school.
Of a higher secondary school. Stop. The predecessor in interest of
Secondary education.
secondary
High
school.
secondary. High secondary school. Ultodanga United High School, high secondary.
Sir, the petitioner, the predecessor in interest of the petitioner filed a writ petition being during his lifetime. Now, page first one is
Page 44, Malat.
page 44. The petitioner, the petitioner in interest of the petitioners filed a writ petition being WP 17925 within bracket W of 2005 to have his retirement benefits disbursed. The said writ petition was disposed of by the order dated in November 9, 2005, directing the authorities to take steps for issuance of pension payment order within 2 weeks from the date of receipt of relevant receipt of the pension papers. Stop. The petitioners, after the death of the concerned teacher, filed another writ petition being this writ petition was ultimately this is the only writ petition, only one writ petition.
Yes, Malat.
Huh?
Yes, 25th November 2010. Order.
This was an interim order.
Yes, interim order.
Okay, লিখলাম
Disposed of.
না একটু আগে থেকে পড়ুন। Stop করে কেটে দিন। An interim order was passed in the said matter on November 9, 2005, directing the school authority to send it to the Director of Pension and Provident Fund and Group Insurance for issuance of necessary pension payment orders. Pension payment order in favor having pension order. Stop. The 2010 he was alive.
No. He died, Malat, in 2005. 2005 he was alive, but 2010, Malat, 2005, 25th May 2001, he died.
Huh?
He expired, Malat. 25th May 2001.
Then who moved? The Ajay Kumar Maiti
Malat,
was alive when order dated
He is the son of the deceased employee.
Ajay Kumar Maiti is the son of the.
he did not get the. Oh, sorry.
Jotindranath Maiti is the original.
কি লিখলাম বলতো?
No,
ভুল হয়ে গেল, প্রথমটা থেকে বলুন।
both the writ petition has been filed by the.
না, প্রথম দিয়ে পড়ুন, পুরোটাই লিখুন তাহলে। The predecessor and interest of the petitioners was an assistant teacher of a high secondary school. He retired from his said service on
24th March 1990.
March 24,
4th March 1990.
1990. Stop. But did not receive his retirement benefits during his lifetime. Stop. He died on
25th May 2001.
He died on May 25, 2001. Stop. The petitioners, being the heirs and legal representatives of the deceased teacher, filed a writ petition.
Only son, my lord. Then only one son, Ajay Kumar Maiti, filed that petition.
Sorry. The son of the deceased teacher, the petition number 1 hearing.
Yes.
Petition number 1.
Filed a writ petition being WP 17925 within bracket W of 2005. Stop. In the same petition, the earlier order was a pension payment order. How can it be issued? I don't know. Okay. An order was passed on November 25, 2010, directing the Director of Pension, Provident Fund and Group Insurance West Bengal, the respondent number 3 herein, to decide the claim for retirement benefit of the deceased teacher after granting opportunity of hearing to the petitioners the school and other interested person. So, the exercise in this regard was directed to be completed within 12 weeks from the date of receipt of the copy of the said order. Unfortunately, the said petition got dismissed for default. Stop. The petitioners, by the instant application petition, is praying disbursement of the pension and other retirement in benefits. Stop. The petitioners complained that no action was taken by the respondent number 3 to implement the order passed in the earlier writ petition dated November 25, 2010. Stop. The said respondent is directed to file a report before this court on the adjourned date, clarifying the steps taken in terms of the said order dated November 25, 2010. Stop. Matter be listed on 22nd August. You get a clarification that this order, what steps you have taken. If not taken, how soon it can be given to them. Take back your instruction. Every service with you. এর শেষ হয়ে গেল তো 16 অবধি।
Sir, Lordship, before your Lordship start this, I may submit that the Honorable Division Bench has already upheld the virus of Section 10C of the West Bengal School Service Commission Act. Now, Lordship, we have challenged the policy of the transfer, and our contention was that this is violative with the provisions of the Act also and the scheme of the Act also.
Violative of
The scheme of the Act also, this policy.
that
The policy
one writer,
makes-
Mr.
yes.
Chatterjee, one writer.
Yes,
Whatever argument made before the division bench
cannot be
and
reopened.
finding returned by the division bench,
Yes.
don't repeat it.
It cannot be
Because it
reopened
will be
at all.
very costly for the petitioner.
Yes. What I propose today, since the Advocate General is present here, this judgment of the division bench, which can be used as a reference or guidance, this court to examine this policy in hand, because the division bench, while reaching to this
Chatterjee, I am
conclusion-
only hearing the personal ground of challenge of recommendation.
My
That
lord,
I
the question
making
is
it
that,
very clear. I have been recommended, but these are my difficulties.
yes,
This is my difficulties, and here the areas where
Yes.
it offends the
yes,
policy.
I'm on that only. Before coming to the personal ground, Lordship, what are the grounds which has to be considered by your Lordship is possibly some guidance are given in the decision of the division bench, because division bench, while reaching to the conclusion that Section 10C of the West Bengal School Service Commission Act 1997 is intravirus, actually attempted to harmonize the entire policy of the transfer.
If any observation comes in your way, do it.
Now,
Refer it.
No.
But first of all, you have to satisfy me whether
my-
this
so
petitioner
Lordship, what I
are the
propose
grounds of
that
challenge.
from this guidance principles, before coming to this grounds of challenge, I want to point out few things from the policy and judgment of the.
No,
Honorable
first of all,
Division.
you come to your ground.
No, Lordship, before that it is important, otherwise.
Please
Lordship,
tell me
this
what is
will
your
be a
ground.
futile
Please tell me
exercise.
what is your ground.
Yes, my lord, kindly come to the policy first. Because
Proposal, where
grounds
is the proposal? Where is the proposal? Recommendation.
My lord, recommendations are annexed in the annexure P1.
You have been recommended for transfer.
Yes,
Where is that recommendation?
107 kilometers from my place. This is page 16.
Page 16.
Yes, before your lordship goes, this is the creature of the policy. Now, lordship, kindly come to the policy once.
Your present school is Maharaja Kasim Bazar.
Yes,
You have been asked to go to
this is to Kadampur,
Kamdep.
Kamdepur, Snehobala, Milan Vidyapit. This is in South 24 Pargana. This is transfer from one district to another district.
That offends the policy.
That's the one. Now,
No,
lordship,
you guys, please, one.
yes,
Meet the
I have,
query of the
lordship,
court.
my supplementary affidavit is.
Wait. Meet the query of the court. Now, this is your recommendation. You are in this school, have been transferred. to Patna.
Yes, my lord. And this person,
What is your pleadings in support of that?
yes, supplementary affidavit was permitted to be
The
filed.
main
There
petition.
was the order. I prepared the supplementary affidavit. Yes, sir.
No, first of all,
Has not been served.
Mr. Chatterjee, let you first.
Oppositions have also
Oh.
been prepared.
They have also come up with one.
Chatterjee,
Lordship.
please come to your main petition.
Lordship, there was a
Where have
direction
you-
for filing
Yes,
supplementary.
I will be looking
Yes.
into the first your application. Where have you stated anything about it? Paragraph 6, I am getting in violation of the
Yes,
School Service
Lordship,
Commission
that
Act.
is their detail I have given in
Are
supplementary.
you pressing it up at the 10C, paragraph C,
Where?
paragraph C, 6.
While this your petitioner states the matter utter surprise, petitioner received the impugned order and found that impugned order was passed completely in violation of the provisions of the School Service Commission Act 1997. Yes,
It's still.
because I have not challenged the constitutional validity of any of the sections.
But it is in violation.
I have challenged this is in violation of the existing act. Lordship knows
This
the
is one challenge. Then
number 2(7), your petition states that West Bengal School Service Commission Act 1997, in order to constitute a regional service commission and the Central School Service Commission in West Bengal and for matters corrected therewith, incidental thereto, by the preamble, the act lays down the matters connected with the School Service Commission in relation to the jurisdiction to discharge the duty in accordance with the provision of the act, but not in any other matter that can be imported to the provisions of the act, which may run counter to the code. The minute reading of the act will show that act never intended to get the transfer as condition of service of the teacher recommended by the School Service Commission and ultimately appointed by the concerned school.
pause here for a moment.
Yes.
Has this point has not been argued before?
It has been argued, and the solution given to this is the harmonious construction. That is where I want to rely on.
Therefore, one of the grounds has already been dealt with by division bench.
Lordship,
That is the caution. Please don't repeat.
I am not
what has
repeating,
been.
Lordship. I say that 10C is inter virus. My stand is very clear. 10C is inter virus with the rider that 10C has to be read harmoniously with other provisions related to the transfer. Why I am pressing it? Lordship may find this policy. Kindly come to the policy once. Lordship, kindly come
These
to
are the two grounds you have taken.
This is the legal point.
No, these are the two grounds you have taken.
Yeah.
Now, what is in the supplementary evidence?
This is the distance, district, and my ailment, physical ailment.
These are the coming under this?
Yes, supplementary. Now I have 6 points. Before that, Lordship, kindly come to the policy, whether this policy can sustain in this format. This is important.
Supplementary affidavit to the writ petition filed on behalf of the petitioner be kept with the record.
Let us file our opposition.
No, we have not received it.
So we have also not received your supplementary.
How did you give the opposition to that?
On the main writ petition, today you are filing this supplementary affidavit.
Just to let
He is
them-
prepared. He has prepared this. Don't go into that. Mr. Dr. Patro and Mr. Advocate General also. He may have taken these 2 points, but possibly these 2 points have been dealt with indeed covered by the division bench. And I have made it become everyone conscious that if you repeat it, it may be costly for the petitioner. You come with your grounds. If it appeals to me that this ground is not in consonance with the policy that one should be kept as far as practicable within the district, personal difficulties should be considered, that I will consider.
Lordship, one thing, Lordship, kindly come to the policy once.
Yes, I am coming to you as you are.
Yes, madam, this is
pressing very
important,
hard.
Lordship, according to page 24. Because I think if I demonstrate this, that will suffice the purpose. It would be, Lordship, kindly come. Backgrounds. As per the state policy, the state is bound to maintain required number of subject and group of teachers in terms of the government order regarding bare minimum staff pattern to be maintained in the secondary schools for ensuring right of the children to get education in schools. The state, being welfare state, has to be benevolent to its teacher who are appointed in recognized state-aided sponsored schools and had no avenue for transfer at relevant point of their appointments. Thus, within the framework of law, transfer policy was introduced by the state government in 2012. Initially on mutual basis by 2 consenting teachers, then by means of general transfer on basis of their applications. These 2 avenues provided to the teachers to get preferable posting by means of transfer. Now, Lordship, by virtue of this division bench judgment, these 2 policies has to be revived. And these 3 things should go together. Then only the statute can be read harmoniously.
This is background.
This is the background on the basis of which this policy was introduced. My lord, I am on the basis of the policy. I'm here. I'm not challenging their power to transfer because I know in order to fulfill the teachers' need of the teachers, this power should be there. This is my stand. That's why I've not challenged the constitutional validity of 10C. I say once 10C is to be enforced by the state. State should first open up 10A and 10B avenues, which is presently closed. The policy itself says transfer policy was introduced by the state government on such and such. These avenues were provided. For availing means these transfer avenues, teachers get posted at their convenience, which has sometimes caused the disproportionate PTR in some schools. There are observations of the Honorable High Court to rationalize the teachers for protecting the educational right of the children of the school suffering from. Thus, for protecting the educational right of the students as well as for optimum utilization of manpower and realize full potential of such teacher, a policy of rationalization of teachers working in recognized non-government aided sponsored secondary schools in the state is much needed. Now, Lordship, I say this policy is for the rationalization. It has to be rationalized.
Therefore, as you are reading the backgrounds in a way, the background and the policy thereafter laid down are contradicting each other.
Yes. These three things should, because harmoniously, harmony means together. Togetherness is the essence of harmony. Now, Lordship, suppose 10C is now operative. 10B and 10A.
Again, I'm reminding these points have not been dealt with by division bench.
These points have not, because division bench has given a light to this point, that it has to be harmoniously read. Because that's the source of power. Ultimate power is the transfer. By on 10A, 10B, the application will go from the person, incumbent, and 10C by the state.
Where is the harmony has been offended in the policy? Where harmony has been?
Harmony, Lordship, now they admits that 10A and 10B, because kindly come to the last paragraph. 7, the state government, keeping the situation in mind, also decided to take long-term measures to protect the schools from being teacher-less as follows. The School Education Directorate and Secondary Education Branch of the Secondary School Department, West Bengal, will conduct exercise drill in terms of the Section 11 and 12 of Control of Expenditure Act. No application for own seeking transfer shall be allowed from the schools having adverse subject group subject PTR. Now, this cannot be introduced in this way because 10A and 10B also gives rights.
Are you in a mood to apply for transfer? Your client in this matter.
Lordship.
You have said that where have we read this? Should take me to that. Where have you read? Now just have read from where?
Last 7. 7B.
Measure to protect the schools for being teacherless as follows. The school directors such and such will conduct exercise drill in terms of 11, 12. The teachers for school having less on frequent basis as per such and such. No application for own seeking transfer shall be allowed. Are you offended for that?
I'm seeking that. I have already cleared my grounds for challenging. Now whether I am offended or not is not the question. Whether the
You
policy
have a
is
cause of action to this.
Yes,
I'm
because
not
I've
hearing a
challenged the
public
policy.
interest litigation.
I've challenged this policy because the division bench clearly states, Lordship, kindly for a minute. It says that transfer policy, it has to be 3 words. It has to be reasonable, it has to be just, it has to be fair.
Where have you stated in your pleadings that these are the areas?
Because this is coming after the division bench judgment, Lordship.
And you are filing the supplementary.
Prior to that, prior to pronouncement
Don't
of
file
it has been
Make it clear, easy for them to meet your point. Arguing a length. It's a huge number of petitions are pending.
Lordship, kindly come to this
Make it
now.
very clean that these are the policies defects, which is not, these are the grounds of my challenge to the policy, bring it to the pleadings. What I am getting, that 3 paragraphs of your original petition already been dealt with, subject to what
I have not
Mr.
received the
Advocate
copy. Now,
No, the writ petition. What Mr.
Writ
Advocate
petitions,
General
the
will
opposition
say,
have
what
not
Dr. Patro will say, that possibly this paragraph 6 and 7 has been dealt with by the division bench in its own way, relevant to the issue. Now this supplementary
they will come up with this. Let them come up with this.
Now you are taking me to this.
I'm coming because they cannot. I say that this policy in this form, if this cannot stand, and this policy, if in this form, if it is allowed to continue, that will not possibly render the information which your lordship wants, that is the information related to the PTR. Because this policy says the endeavor has to be given to keep the teachers within its districts, whether they have the state-wise vacancy list with them, whether it is based.
Modality, they will decide.
Now,
You
wait.
show that these are the modalities have not, since had not been carried out, I am affected thereby. Your specific case in this.
My distance, my district, that is why I request.
Your district, that district, the teachers should be kept within the same district. That is the object of the policy. I have. been
Whether
trans-
that endeavor was made by them.
In transferring you,
Yes.
in transferring you, rather.
Because I'm in Kolkata. Is it a case that there is no vacancy? There is no school which requires the teachers in Kolkata?
Possibly they can demonstrate it very openly. They can demonstrate in Kolkata school. They do not require. They are under the obligation to keep those school open without student even.
No, that may not be the case.
Not be the case if you.
May
want-
not be the case
But
until they keep this PTR lordship.
Individual, keep this individual cause of action within the four corners of your challenge. Don't try to expand
I'm
it.
not expanding lordship. I'm within.
Now,
the
would
four
you like to recast your supplementary affidavit to bring it? What are the exact ground of your challenge?
Lordship, I have given it. If your lordship wants the division bench guidance, lordship, what does?
No, division bench guidance, we will see that. Mr. Advocate General is there, Dr. Patro and other petitioners are
Fine.
there. But I want to know, you are attacking the policy and that these are the grounds
Yes, the 6 grounds
relatable
are-
to your cause of action.
6 grounds.
Relatable to your cause of action.
From my facts, lordship, I said that district is
District
one
I got. there.
affected. Then lordship, it says. Lordship, may I get the supplementary evidence back?
Yes.
My learned friend is harping on the district issue, but my learned friend is then to place the policy. It is not absolutely that you will get it within the district. If
That-
necessary, you can be sent to the next district. The policy says so, but my learned friend does not.
Whether that endeavor was given.
Yes,
That's why we need the data. That's why we need the
Mr.
clarity.
Chatterjee, think about the, please, I will not be happy to impose something which is not very easy.
No,
for you.
lordship, that.
Please,
the only
don't,
thing is-
don't enlarge the issue.
I'm not enlarging,
we are
lordship. Is it a question?
900
I'm
more
asking.
teachers, 900 more teachers are in the queue to be transferred to different schools. These schools are
Nobody has
wanting-
been
What is
transferred
the
yet.
figure? What is the
They
figure?
also wanted, they issued.
My lord started, my lord, there was 605.
Hmm.
My lord, where recommendations had come in. Now, your lordships would recall, my lord, your lordship also wanted me to check whether there were, my lord, any violations, my lord, of the policy, or my lord, certain portions had been overlooked. My lord, what I have checked, my lord, till now I'm indicating, my lord, out of the 605 transfer orders, my lord, 3, my lord, were, my lord, double transfers in the sense.
No, I have got one matter where the authority said that this was a wrong transfer because she was the single teacher in the school of the subject.
So, my lord,
She is not the surplus teacher.
yes, so my lord,
Immediately that order was recalled.
so my lord, this is what I have checked. My lord, so my lord, I have, my lord, given my lord advice, my lord, as far as those, my lord, recommendations are concerned, they should go. And my lord, 100 others, my lord, initially, my lord, it was a group of 60. My lord, further investigation has revealed that out of, so it comes down to, my lord, from 605 to 602, 603. And my lord, what has been found, my lord, is out of that, my lord, 100, my lord, there were, my lord, deviations. My lord, so, my lord, even those, my lord, have been asked to, my lord, to be, my lord, kept on hold. The others, my lord.
No, since you are here, another query, incidental query is coming in my mind that there was some circular on behalf of some that
That
why?
was handed up to your lordship.
Yes,
My lord, lordship sent for me. My lord, I dealt.
this
with
was wrongly issued. I
it. Correct. So I, my lord, I-
corrected.
my lord,
Education, the board is feeling handicapped in issuing this transfer order.
no,
It was said by deputy secretary. What is that issue?
No, your lordship, my lord, your lordship.
Please
said-
take steps. Please
Very
take
well, I'll
steps.
speak to them.
Please.
Lordship, what I propose,
This
Lordship,
is not your, this is not your thing. Mr. Advocate General, please advise this Deputy Secretary. I was about to call him in court.
Your lordship sent for me instead, my lord,
Yes.
that day. My lord, I told your lordships, my lord, there is no, my lord, it is not, my
The
lord,
policy is not on hold.
not on hold at all.
I'm hearing this matter
Yes, yes, yes.
individually. It's not at all hold. I'm making it clear.
Yes, yes, my lord, I am, my lord, making the statement before your lordship. It's not on hold. My lord, these were being issued, my lord, for the purpose.
Please
of-
recall it or take
My lord,
steps
clarify
so
it, my
that
lord.
court can feel
Yes.
comfortable in issuing that. You want to propose to file the affidavit today or
Lordship,
you want
give
to
me
recast
2
it?
days time. 2 days time.
2 weeks time.
2 days.
2
not
days.
2 weeks.
Very well.
Because if Lordship, if I fail, Monday.
Opposition, I think that you use your opposition after getting the.
But we have already affirmed our opposition because they did not serve their supplementary affidavit within time.
Uh,
So,
Let me take it. Let me
this
take
be
it.
kept on record. And if they take any new
Mother,
points in
then
the
let us-
supplementary affidavit, I will deal with
Mr.
it.
Chatterjee,
I will.
clarify it. These are the places you intend to challenge. the-
Lordship, what I will do, whatever, everything is there. I will prepare one short note and give it to them, give it to learned
No, no,
advocate general.
everything is not there. Because on pleadings, my lord, I am willing to take him on.
Yes, yes, on the
On
pleadings.
pleadings, he'll go
Bring
today.
bring it in pleadings. That these are the subject of my challenge and include it in your supplementary affidavit. Don't give it piecemeal. Include it in your supplementary affidavit. Mr. Chatterjee, include it in your supplementary affidavit.
Lordship.
These are the areas of my challenge to my recommendation for transfer.
Lordship.
Personal cause of action. You are not doing the public interest litigation.
Lordship.
Assun to. Affidavit in opposition filed on behalf of the commission be kept with the record. And Mr. Advocate General, you may require to file an affidavit.
Yes, my lord,
at least in
my
one
lord,
matter.
my lord, I'll tell your lordships, my lord, why we had not done it. My lord, your lordship.
Yes.
My lord,
Let
because that was
it develop.
pending, that was
Let
an
it
interim
develop
order.
in its
Yes,
own way.
yes.
Very well.
So, my lord,
Very
kindly
well.
give us some time, my lord.
Very well. এটা হলো তো?
My lord, we'll file it after the supplementary.
Exactly,
affidavit, so it
exactly.
deals with,
So
my
that
lord.
you can
Yes.
deal it at, when you will be filing your supplementary affidavit,
Lordship, I require 2 days, Lordship, if your Lordship want.
come on.
Only 1 week,
Monday is the monthly list.
1 week time, Lordship.
Come on 8th August, Tuesday.
8th August.
You'll feel free, then you come on 8th August. I
8th
don't
August.
mind.
Or Lordship, after 15th.
After 15th.
A bunch of these matters are fixed.
All.
on 10th.
I'm a recording order. Fixed on?
A bunch of these matters are fixed on 10th. Because Mr. Lahiri, Shubhra Lahiri was not well and he had prayed that, so his bunch is fixed on 10th. So let it be on 10th.
All
It will
matters?
frustrate the matter, that's all.
No,
Nothing will
please.
happen. Nothing.
10th August.
Those দিনে
Come on
চলে
10th
গিয়ে।
August.
10th August, Lordship, is possibly on
Thursday.
this Thursday, the next day.
না ওটা থাকছে না ফাইল কর না opposition matter be placed on the list on 10th August for further hearing
Grateful.
to come with your supplementary affidavit and all transfer matters will be coming on that day. Whoever in the petitioner, I'm not recording a formal order. Keep it with you. All come on 10th August. All come on 10th August. Come on 10th August.
Actually, my lord, this came up for consideration of the Honorable Appeals Court. This is reported in 2023, 315.
Oh, this is already considered.
Huh?
Already considered.
Yes, if your lordship may kindly consider subject to question because Mr. is not here.
This is Amendment Act,
Yes, consider the
Yeah, for-
amendment
2016 Amendment.
26. The issue, my lord, if your lordship may kindly consider what are the issues?
Yes.
Yes, যশোরের ওই ইয়েটা দেখাচ্ছি 23 অ্যাক্টে যেটা সেই জাজমেন্ট হয়েছে 2023 যশোর জিজ্ঞেস করছিল আগের দিন যে অ্যামেন্ডমেন্টের ইয়েটা কি আছে রাজা গোপালের সিরিজ যেটা হবে ওইটাই সেগুলো এইটা আমি আগের দিন পাঠিয়ে দিচ্ছিলাম ইয়েকে
অ্যামেন্ডমেন্টটা কি? হ্যাঁ, আমি তো পাঠিয়েছিলাম বোধহয়। আমিও
হ্যাঁ
পাঠিয়েছিলাম।
হ্যাঁ ওইটা
I'm sorry, my lord. I was before a division bench. In fact, the appeal is continuing. Mr. Mukherjee is leading me, my lord. I was very embarrassed to leave him. So, do not know, my lord. It's very embarrassing for me, my lord, to.
But I have fixed this matter.
I know. I ought to have come up here before, my lord.
No, I'm a little bit late because I was late in concluding my first half.
It's very embarrassing for me, my lord. A senior like him.
Take his leave.
No, that he would never say no. That's further embarrassing.
And if he particularly if he hears that there is a second appeal going on, possibly he will not be objecting.
No, I informed my lord, his man that I have to go before. I did not say that, but I said that I have to go before your lordship for a 2 p.m. fixed matter.
If you miss today, it is very difficult for me to accommodate to you any other future date.
No.
Very difficult for me to accommodate.
73
Without.
73 যেটা 96 পাতা হ্যাঁ 96 পেজেস না 2023
96 pages.
হ্যাঁ
কতগুলো পাতা আছে দেখে বল।
গণপতি হ্যাঁ গণপতি যে কোন তো 96 পেজ perspective and retrospective. One part perspective, other part retrospective.
So defense taken, that will continue.
Yes.
Deal Miller, Deal 61, 2016. Deal that date.
Subsection 3 has been deleted in 2016 amendment.
That has been held ultra-virus also, 3 subsection 2.
Ultra-virus.
Ultra-virus, 3 subsection 2. Judgment, one of the 3 judgments.
Which portion has been
Yes,
declared also?
it is there, my lord. বইটা বার করে দে না। না।
Lord, conclusion, paragraph 18.1. Paragraph 18.1, conclusion.
18.
18.
80.
18.
Conclusion is where I don't know. It's 106 paragraph judgment. Conclusion of this judgment. Paragraph 16.
2023-3 SCC 315 ওইটার সঙ্গে মিলবে না। না,
This is online.
no, that's the judgment of the Supreme Court, my lord.
2023 3 SCC 315.
This will tally with the SCC book
285. Oh, SCC
315.
SCC online. Sure. 16 point. What the conclusion? Conclusion 18-1.
No, no, no.
Paragraph 18-1. 18.
Conclusion only.
ও এখানে একটু ডিফার হতে পারে।
Oh, my, kindly come to my lord, paragraph 127, which 127.1.
127 point.
127.1. Just at the end.
In view of the above discussion. Section 3, unamended 88 Act. না এটা ওইটা
এটা তো unamended নয়, এটা তো amended.
Have you got a copy of the unamended book?
No. It, well, it shows the previous provision also.
Note below.
No. In the section itself, and note says that this portion was omitted. Kindly come to my lord. Kindly come to section 3, subsection 2 as it is there. Nothing in subsection 1 shall apply to A, the purchase of property by any person in the name of his wife or unmarried daughter, and it shall be presumed unless the contrary is proved that the said property had been purchased for the benefit of the wife or the unmarried daughter. B, the security is held by a depository as a registered owner under subsection 1 of section 10 of the Depositories Act 1996, participant as an agent of a depository. Then explanation, the expression depository and participant shall have the meaning respectively assigned to them in clause E and G of subsection 1 of section 2 of the Depositories Act. Now this was, my lord, omitted, as would appear from, my lord, the note below. And then, my lord, 3, existing subsection 3 became, my lord, 2.
3.
Existing 3 became 2. Lordship will find possibly there are 2 2s.
Well, nothing in the subsection 2, then 2, whoever enters into
Yes,
the
that
benefit.
was already, that was there as subsection 3. That has now become subsection 2.
And 3 remains.
3 remains.
Inserted, no new.
No. 3 is inserted.
Now, what has been declared unconstitutional?
3(2), the penal provision, my lord.
(3)(2) of the unamended. Which portion has been declared to be unconstitutional? 3(2) has been wholly omitted.
No, it's
now 3 become 2.
It's but kindly don't go into this.
kindly don't go into this. For the simple reason, my lord, according to me, my lord, the penal provision was, my lord, held to be, my lord, unconstitutional. That would appear, I was reading the judgment, that would appear from the text of the judgment.
Penal provision inserted by omitting the original two, replacing it by.
Which was there as 3, that is, my lord, declared as unconstitutional.
Effect?
No penal step can be taken. But possibly, my lord, we are not.
No, not really. This is, we
My
are
lord,
not
your
at all.
lordship may require it, my lord, I don't.
No, at least not required in this matter, please. At this is not required. But so what about 4? 4 subsection 3?
Notwithstanding anything contained in Code of Criminal Procedure, an offense under this section shall be.
No, subsection 4 of subsection 3 of section 4.
Oh, I see. No, that goes.
That goes.
That
When?
goes.
2016.
That is yes.
That goes in 2016. Now, the suit of which year? 2011.
Yes.
Defense taken in parity with subsection 3B. Defense taken.
Yes.
Then if it goes, then
Yes.
as of today, what is the stand now? 3B, I'm making it clear. Subsection 4, subsection 3B.
Yes. Either A or B. What?
A or B, either A or B.
Yes.
Subsection 3.
Yes.
The tenor of defense is taking this defense already taken in 2010, 11, 2016 it goes effect as we are considering this provision today as of
Since,
today.
my lord, no retrospective effect has been given, it's prospective. So you cannot take, my lord, as I understand.
No, of course, because this line, this Mithilesh Kumar is, or rather Raja Gopal Reddy.
Yes, the
Raja Gopal
yes.
Reddy case.
Yes.
Defense already taken.
Yes.
Does it mean
Continues.
paragraph 73 has clarified that position? Paragraph 73. That was one of my queries
Paragraph 73
of this judgment. It is still available to the appellant. If we go by Raja Gopal Reddy, then it's still available. Of course, subject to proof of that ground.
Yes, definitely.
What do you say?
2(9), the portion has been omitted, inserted under section 2, subsection 9. Definition of those.
Section
9 এতে কি ঢোকা
ওই
যাবে?
যে স্যার, এটা যেগুলো ইয়ে করেছিল না? No, এটা না।
9 এ?
হ্যাঁ, হ্যাঁ।
What has been omitted?
No, inserted, my lord. এই যে এখানে benami property means, a benami transaction means, my lord got it? A transaction or an arrangement where a property transferred to held to a person and considered property has been provided. The property held to be immediate future, a quarter.
By another person.
By another person, no, এটা আগেরটা। আমি এটা 2(9). এই যে এই যে। এখানে নিয়ে এলো স্যার, দিয়ে বললো
The B এর পরে দেখুন স্যার 9th section B. After that, the property is held for immediate or future benefit, direct or indirect, of person who has provided the consideration, except when the property is held by. Then one of the portion is omitted from subsection 3(4).
4 subsection 3.
4 subsection 3, that has been included as III.
To bring it within the purview of Benami transaction. But we are not concerned about that. We are now concerned since a defense has already been taken. As it now, he has developed another point here in the second appeal about this joint state. But the original defense as it appears from the written statement that the property was purchased by the father for the benefit of the whole family. To bring it within the subsection 3 of section 4. My query was when the subsection 3 has been omitted in 2016 during the pendency of this second appeal, whether that defense is still available to the appellant or not. The answer is Raja Gopal Reddy and this judgment.
And this judgment, my lord,
Is that
according to me,
defense
my lord,
already taken available? So we need not
because
go
it
into
was
that.
not given a retrospective.
Nothing has been done, whether prospective or
No,
then
it has been held, my lord, that
by paragraph 73. Possibly, section 4 remains the same under the 1988 Act, barring this fact, the subsection 3 has been integrated the expression provided under the definition of the Benami transaction 29. Civil consequence provided under continue to apply even on the post 2016 Act. Civil consequence will follow. But in his case, it is his benefit because as given in Raja Gopal Reddy's case, continues to apply. So he can take that plea. My query was if he is not allowed to take this plea in view of this amendment, then why should we go into that question of the volume of evidence and everything? To cut short the matter. Unfortunately, the court failed, has failed. Yes, now, what more you want to?
yes. Now, my lord, on the last occasion, my lord, if I remember it correctly, that your lordship wanted, my lord, to see whether the first appellate court judgment deals with the documents. Now, kindly come to the first appellate court judgment, my lord, at page 39 it starts. Kindly come to page 46 onwards. My lord, I shall directly go to the relevant portions, my lord.
Page.
My lord, the judgment starts at page 39. Kindly come to, my lord,
page
55. The decision starts really at page 47, but kindly come to page 55. At the top. The sale deed of Schedule A land is always under the custody of the appellant. The conduct of the parties after the purchase of the said land has been seen cordial till such as sale deed is taken into consideration. That is my document in any event. I produced it. Now, my lord, kindly come to
and it remains in the custody of the appellants.
The plaintiffs.
Yes.
Now, kindly come to page 57.
So, Mitro, would you kindly discuss, because the conclusion of paragraph 12, in view of the above mentioned, it appears that sale Schedule A property does not come under the purview of the Benami.
Yes.
His conclusion.
Yes.
Why? How?
Yes. That would, my lord, appear from, kindly come to page 53.
Yes.
Page 53, the last paragraph. On careful perusal of section 4 of the Benami Transaction Act and observation held by our apex court in a case law reported in 1980 volume 3 Supreme Court cases, it appears that following are the vital tests for determining the fact of Benami. The source from which the purchase money came, the nature and possession of the property after the purchase, motive, if any, for giving the transaction a Benami color, the position of the parties, and the relationship, if any, between the parties. Then, my lord, E, custody of title deed after the said
There is that. Custody of the title deed.
Yes, yes. It's there, my lord. I shall place that Supreme Court 1 second.
Yes.
The Supreme Court decision. The conduct of the parties, etc. Now, my lord, this is one. First, in any event, this is my document, so they cannot be aggrieved that my document was not taken into consideration.
Very important as regards source of income.
Absolutely. Absolutely.
That no specific business of Sharad Chaudhary has been mentioned by the
Yes.
respondent. Mentioned by the respondent.
Absolutely.
Therefore, you may argue that the burden of proof has rightly been shifted on respondents to prove the apparent state of affair is not the real state of affair. In a Benami.
My lord, the burden, with respect, my lord, the burden of proof, my lord, was on them.
Was on them.
It
That
did
is
not
what the
shift.
appeal court is proceeding.
It did not shift.
Appeal court is proceeding on that.
Yes.
That the burden of proving that the real state of affair, apparent state of affair is not the real state of affair.
That is on
The respondents of the appeal. That means that the defendant. But they
whoever
have
takes
only,
this point.
yes, only the no specific business. Our source has not been proved.
Yes.
That was on the person who is claiming to be the owner of the ostentatious owner of the. Okay. Understood. Different villages, hearts.
Yes.
It is correct finding based on evidence.
Absolutely.
There is no business except any as regard income, no specific business of Sharad Chaudhary has been mentioned.
No, I had in fact on the last occasion demonstrated before your lordship the partnership deed, which showed, my lord, when the partnership deed between the father and the sons, my lord, commenced.
Already property purchased.
Long after, long after. 69, the property was purchased in 1960. And interestingly, my lord, this allegation that, my lord, the the father used to, my lord, fare his things, my lord, in different hearts. My lord, nobody came to give evidence to that effect. The defendant's witness, DW1, was born in 1970.
That is exactly the next question I was going to. Please, if I forget to put you that question, how far the facts which actually admittedly held or occurred long before the birth of the witness who has come to depose to prove the written statement case.
Could not have. A specific question was put to him that, are you calling your pishes to give evidence? That was avoided. The sisters were not called. In fact, the other brother was also not called. Who could have said something? Who was allegedly kicked out from the joint property?
Yes, Mr. Mitro, supposing a case, a grandson wants to prove acquisition of title in a case of his grandfather. in a certain way, how he will prove?
It can be by production of documents, my lord.
Only.
Or, my lord, if oral evidence is required, my lord, in my submission, subject to, my lord, correction by Mr. Banerjee, my lord, that somebody who was there at the relevant time.
So something more except the oral evidence is necessary.
Oral evidence of that person.
Something more of that particular witness who never had an occasion to see happening of those circumstances, something more is required. So either documentary or corroboration by somebody who has witnessed that event directly. Otherwise, it may be affected by the doctrine of this hearsay evidence, may be affected. Mr. Banerjee to answer. Yes, all is for you. Then,
now, my lord, kindly come back to this judgment. They had documents, my lord, kindly come to page 57.
Page 57.
Second paragraph. Well, I'm not placing the first paragraph which speaks about, or kindly come to page 56 bottom. Last paragraph. It has been stated that a partnership business was run amongst the brothers of the appellant and his father in the year 1969. This I had showed. But no partnership deed in this regard has been produced before this court, so it is impossible to believe on it. Very well. No, nobody produced the 69 partnership deed. 73 partnership deed was produced where it was referred that the parties are carrying on business since 69. Next. Further, second partnership deed amongst the brothers of the appellant was made in the year 1975. The third partnership deed was also made in the year 1979 and a family settlement was held in the year 2009. All this partnership business are not related with the Schedule A property, but the said partnership deeds have been made for the purpose of running tea garden business, etc. Though they acquired money for themselves, from themselves, out of those business, but there is no documentary proof to show that they have invested any amount for the renovation of the building situated in Schedule A property. Further, IT returns for the year 2002, 3 and 4, which have been marked as exhibits C, D and E and submitted by the respondent, it appears that the said IT returns have been filed by the original defendant and the address of the original defendant is shown as such and such, which is presently situated and such and such. Kindly turn the page, my lord. Kindly turn the page. I am omitting this. So and so rupees at the top for the year 2003 and rupees 51,020 have been spent for the building renovation, but the specification of the said building has not been mentioned
in the IT return.
I showed your lordship on the earlier occasion, on the last occasion, this exhibit BCN.
Even some money is spent, supposing, how it affects the ownership of it?
No, it does not in my full submission. My lord, I stay with my brother in his house and I renovate the house, or my lord, I spend some money, my lord. I don't think that I can subsequently, my lord, go and claim that I am the owner of the property.
Dangerous proposition.
Absolutely. Absolutely. Then, in such circumstances,
will be affected most. Mr. Banerjee will be affected most.
Taken care of. In such circumstances, it cannot be believed that those amounts mentioned in the IT returns have been spent for the building renovation of the scheduled property. So these documents have been taken care of. Next, kindly come to 14. Further, regarding possession, it is an admitted fact that both the parties are living in the suit premises. The appellant is residing in one part of this 8 building, whereas the respondents are residing in Schedule B, it's not E, Schedule B premises in this 8 building. In this connection, the appellant has submitted municipality tax bill, khajana receipt, and valuation report of the building, Exhibit 2 series, Exhibit 10 and Exhibit 13 respectively. All of these documents stand in the name of the appellant. On the other hand, the respondent has filed municipal sanction plan from which it appears that the name of the owners, Dhananjay Chaudhary, Jyotindra Chaudhary and Sachin Chaudhary, have been written in capital letters, whereas the sanction plan has been signed by only Dhananjay Chaudhary. This again I showed your lordship on the last occasion. On the right hand side, only the signature of Dhananjay as signature of the owner, not S. And in the middle ballot, this name of owners has been written. It is the general rule of municipality that signature of the owners are required on the sanction plan. In Exhibit B, the only signature of Dhananjay Chaudhary has been found. In his cross-examination, DW1 has stated that his father, Jyotindra Chaudhary, never used to sign in capital letters. If this be the so, then it can be presumed that the Schedule A and B property are owned by the applicant.
DW1 says that my father never used to.
It was not his signature. That would show that it was not his signature. It was just the names were written. And my statement, from box is, and my case is that, my statement from box is that, my lord, it was misplaced from the office of the plaintiff. They must have done this. And it was produced, the original plan was produced by them. Now, interestingly, the other point. Now, these 3 brothers are 4 sisters. If this was the property of the father, only the 3 brothers would not have been the owners.
If the written statement case is accepted, then the sisters also
then the name of the owners would have included 3 brothers and 4 sisters.
they have the other sisters. It is on the record.
No.
No, they have. Where from? From the record, it will be revealed that the plaintiff has other sisters.
Yes. Evidence আছে দেখো না. Kindly give me a minute's time, I'll show you, lordship. সাক্ষীতে আছে, সাক্ষীতেই দেখি। Kindly, may I read it out? It's in, my lord, the part 1 of this bunch. Page 36. Cross-examination of, my lord, DW1. my lord, page 36, internal page 12, about 6-7 lines from the top. It is a fact that my father and uncle migrated to India from Pakistan. I have got 4 Pishi's aunts. My father used to put his signature in small letters excepting the letter J, which was in capital letter. He never put his signature in capital letters. And then, my lord, I will also find out. Huh? The judgment also reflects that, but kindly give me a minute's time. Yes, kindly come to page 40. 40. Second paragraph. I have got no personal knowledge regarding the purchase of scheduled land by my grandfather. I cannot say that whether my aunts have got any share within the suit property. The written statement bears the signature of my father. Then I cannot recollect the contents. I cannot say that whether there was any existence of Hindu undivided family in respect of our family and whether any income tax file was maintained in the capacity of HUF, etc. কোথায় বলতো সেটাই করছি
Page 40.
এটা পড়লাম তো
I cannot say whether my
হ্যাঁ এটা পড়েছি
ওইটাই আপনি বলছেন
না না বলেছি একটা কোথাও আছে যেখানে বলা হয়েছিল যে পিসিদেরকে ডাকবে কিনা আমার যতদূর মনে পড়ে be that as it may. So, my lord, the documents which were, my lord, relied on by the defendant were, my lord, dealt with by the first appellate court. Yes.
Where is your defendant's exhibit list? Because 46 is the exhibit list of
Kindly.
the plaintiff.
It's in the other bunch, my lord, kindly come to. A to G.
25.
Yes. Part 2, part 2. Second part, my lord, page 25.
What is this registered agreement?
Yes, kindly come to, my lord, this next page, my lord. Family settlement.
This is of 2009.
It has been regarding the business.
There is no reference of acquisition of property or acquisition of business prior to 1960 or like that.
No.
Nothing.
May I show? No. Your
Very well.
lordship
Let
can
us
take it
go ahead. Quick go
Yes,
through that.
very well.
No.
Yes, kindly
Then
come to, my lord.
The appeal court had the occasion to deal with this exhibit A
Yes.
already.
It has said that, my lord, it deals with only the business, tea garden business, etc.
Exhibit B. Building plan, that has been dealt with.
Building plan. C, D, E are the, my lord,
Income tax relating to renovation and other
Yes.
things.
Then kindly come to exhibit F.
F is the certified copy of the RS Khatian,
Yes,
4 sheets.
yes.
Now, one cross-examination had come to my notice that the suggestion was that you have a land adjacent to the suit land
Absolutely.
under the SIGMI. Does this
Same
record of
tag
rights,
number.
record of rights indicates a recording of SIGMI on respect of that plot? The plot belongs to defendant.
My lord, it was the, I have laid evidence that, my lord, because this point was not taken, I have laid evidence to the effect that the defendant has an adjacent plot which was, my lord, granted to him under Sikimi Patta.
Right?
Yes.
Therefore, if this
Adjacent plot has to be
adjacent
same tag number.
and adjacent plot, this is Khatian number 552.
Khatian number is, may have to be
552
different.
Moja such and such, 4 sheets.
Yes,
This is Khatian now. Whose Khatian is this? Defendant's Khatian?
has to be. Page 55. এটা কিছু পড়া যাচ্ছে এটা আমি আমার এখানে
এই অরিজিনাল রেকর্ডটা দেখো তো, একবার দেখে নি, দেখেছি আগে।
না না
Yes, 552, but the technique is the final look. Show it from the record, show it from the record. And take me to that portion where I can relate that this belongs to defendant.
ওটা দেখো আমি ততক্ষণ এটা দেখি
এইটা শুনুন, এটা হচ্ছে দিয়েছিলাম।
Khatian number 552.
এই এটা
Khatian 552 তো
একটা হচ্ছে 412
552
আসতে নেবে শেখ আব্দুল আজিজের খতিয়ান, দখলকার হচ্ছে যুগল কমলা নারায়ণচন্দ্র। এইবার এইখানে যে দাগটা অংশগুলো দিচ্ছে সেগুলো হচ্ছে ইয়ে হয়ে গেছে। এবার সিকমি যেটা বলছে সেটা দেখুন, সিকমি যেটা হচ্ছে আমাদের প্লট নম্বর 1170 কোনো সিকমি নেই, যুগল সিকমি হচ্ছে দেখুন এর উপরেরটা 1169 সিকমি, এটা যুগল দোহে দেখুন
এগুলো রয়েছে
ওগুলো আলাদা আলাদা প্লট নম্বর কোনটা, আমাদের হচ্ছে 1170 রয়েছে যেটা এরকম যেটা আছে যুগল কিশোর দলের হচ্ছে ফুলওয়ানা খতিয়ান এরকম 18170 যুগল দল
এই পড়ে পড়াই তো মুশকিল
1170 3032 ঘর 2 খান বাস্তু যুগল অনুক্রম অনন্ত না ইয়ে তো সিকনি যেটা হচ্ছে সেটা কিন্তু সিকনি আসছে ইয়েতেই নেই তারপর সর্বসাধারণ ব্যবহার্য চিনে আমরা এখানে এই যে এর নিজের খতিয়ান হয়ে গেল যুগলের।
এটা কত খতিয়ান?
এটা খতিয়ান নম্বর হচ্ছে কেটে পেরিয়ে গেল, সুতরাং ওই যে সিকনি যেটা হচ্ছে কিন্তু স্যার এখানে
First page out of 4 sheet, first sheet you are referring to 552?
Yes, my lord.
Dhananjay, Jyotindro, Shotindro. What is the adjacent plot, Khatian?
Your J is there, J. One Khotian, thereafter J. Then division.
Lordship can consider the next page.
Reverse side.
No, not reverse.
Yeah. Reverse it, reverse it.
Reverse. CJ 24, my lord, is the earlier Doug number, which is 1170. My lord, got it?
Yes,
That your lordship friend BT,
VT1.
Jugal Dong. This Montobo column, your lordship find. So it is belongs to Jugal Dong. The nature of land, my lord will not find Sikmi. Sikmi, my lord will find only in before that 1166. That column, that page, my lord, 1163.
Yes, yes, 1169.
1166, 69, and before that 1164, 1163. All are Sikmi. But whether this plot subject to correction, my lord, so
No, the adjacent plot.
yes, now whether these plots are adjacent or not, my lord,
That has not come out.
that is not.
Why 4 sheets were there? Because the second sheet contains Khotian number 81823, so possibly. 823 or 813.
Yes.
Khoti number 813, and 823. 823, it is Jugal's exclusive Khotians. There your lordship find Jugal Dong. On the book column, your lordship find next page.
Why this was produced?
It was filed in that way, the attestation period, my lord, not the final produce. After that, my lord also find the Khotian of Alatram. There, my lord, why it was filed, my lord, can you consider Khotian number 831, next Khotian.
831.
Next Khotian. Alatram.
Yes.
Right hand side of the senior we want. No, same page, at the front page. 15 number column. Sigby. My lord, got it. Now, my lord, pause here for a moment, and my lord, can you turn to the earlier page, that the first one, reverse side. One 166, my lord will find Sigby. Alatram.
So it is not comprised in Sikimi.
In any event, my lord, in my respectful submission, your lordship is not required to go into this.
No, if it is setup of title,
Yes.
acquisition of
This
title.
case was nowhere made out. Their plain and simple case is that I am a joint.
This case has not been made out.
Nowhere made out. No evidence laid.
Two things. The DW1 in his evidence has stated that the adjacent plot, I do not know.
He said, I do not. He said, I do not know. And in any event, that was my suggestion in respect of the adjacent property, not this property. So the question whether this property, my lord, was
comprised in Sikimi.
Was comprised in Sikimi, apparently did not in any event, my lord. That was not an issue. That could not be the issue.
No defense was taken to that effect.
No. My lord, the law, as I find, Mr. Banerjee has cited, my lord, decisions, possibly 2 decisions on this, that, my lord, the appellate court can look into. Yes. If, my lord, the parties were aware of this, they had dealt with this, then the appellate court can look into. I shall show those.
Of course, that you should not take a surprise that where from this are coming.
And lordship will find, my lord, either before the trial court or before the first appellate court, this case was nowhere there. Everything.
Because the question of law is that voluminous document has not been considered.
I could have said that my documents were not considered, my lord. That would have been a different question.
And what is about the exhibit G, the computer copy of bill related
Electricity
to
bill. Kindly come to page 60.
electricity bill stands in the name of the defendant. That is another document. These are the whole documents of the defendant.
Yes.
Very well. Then
আচ্ছা এই বইটা এগুলো কপি আছে তো
হ্যাঁ সব কপি আছে আপনি বলবেন আমি
80 ভলিউম 3টা দে তো
অবস্থা
80 volumes.
Kindly come to one paragraph, my lord, paragraph 18, on which, my lord, the first appellate court had placed reliance.
paragraph
18, 1-8. On the earlier occasion, I had relied on, my lord, 2020, volume 17, Supreme Court cases, page 496. আগে দেখানো হয়ে গেছে।
Yes.
Kindly, paragraph 18. The principle governing the determination of the question whether a transfer is a Benami transaction or not may be summed up thus. 1. The burden of showing that a transfer is a Benami transaction lies on the person who asserts that it is such a transaction. 2. If it is proved that the purchase money came from a person other than the person in whose favor the property is transferred, the purchase is prima facie assumed to be for the benefit of the person who supplied the purchase money unless there is evidence to the contrary. So first, the onus is on the person who is alleging. Number 2 is, my lord, that if it is proved that the purchase money came from, my lord, some other source, then, my lord, the onus shifts.
Presumption, rebuttable presumption.
Rebuttable presumption, definitely, definitely.
Then owner shifts upon the plaintiff who asserts that I am the owner upon him.
Yes.
Your suggestion is that that situation has not occurred at all.
Did not arise. Then 3, the true character of the transaction governed by the intention of the persons who has contributed the purchase money. And 4, the question as to what his intention was has to be decided on the basis of surrounding circumstances, the relationship of the parties, the motives governing their action in bringing about the transaction and their subsequent conduct, etc. Now, my lord, this is, my lord, these are the requirements, my lord, which in my full submission, none of which was.
The appeal court has taken this
Into
aspect into consideration.
Now, my lord, on HUF, my lord, their allegation is HUF property. I would like to rely on, my lord, one decision of the Supreme Court, my lord, reported in 2003, Volume 2, Supreme Court Cases, page 310.
2003,
Volume 10, Supreme Court Cases, page 310. Paragraph? Kindly, madam. I would like to rely on my lord, 3 paragraphs, paragraphs 8, 17, and 18. Or my lord, kindly come to my lord, paragraph 9, my lord. Instead of 8, kindly come to paragraph 9. In such and such, in a partition suit filed against their father by minor sons from the first marriage, the father claimed that the properties in question were his self-acquired properties and denied that the plaintiffs had any right to seek partition. The High Court, reversing the judgment of the trial court, held that the view expressed by the trial court that joint family property was only that which the father took under partition, Exhibit A, was not correct, and further held that whole of the property set out in the schedule to the written statement of the appellant father, which had been acquired after partition, Exhibit A, was joint family property. The contention accepted by the High Court was that the share which the father took under Exhibit A formed the nucleus from which all his further acquisitions sprang. The plea of the father that was accepted by the Privy Council was that the whole of the property that came to him under Exhibit A was intact and unencumbered except a small portion sold, which amount had been debited against household expenditure. The Privy Council held that the Hindu law upon this aspect of the case is well settled. Proof of the existence of a joint family does not lead to the presumption that property held by any member of the family is joint, and the burden rests upon anyone asserting that any item of property is joint to establish the fact. But when it is established that the family possessed some joint property which form its nature and relative value may have formed the nucleus from which the property in question may have been acquired, the burden shifts to the party alleging self-acquisition to establish affirmatively that the property was acquired without the aid of the joint family property. Now, there is no such evidence. Now, kindly come to paragraph 17. In view of the aforesaid discussion, the respondent, having failed to discharge the initial burden of establishing that there was any nucleus in the form of any income whatsoever from item number 2 property and no other nucleus was claimed, the burden remained on the respondents to establish that item number 1 property was joint family property. In this view, the fact that the first appellant has not laid any evidence to establish his separate income is of no consequence insofar as the claim of the respondent is concerned. Under those circumstances, for failure to lead evidence, the respondent's claim of item number 1 to be joint property would fail as rightly held by the first appellate court. The legal principle, therefore, is that there is no presumption of a property being joint family property only on account of existence of a joint Hindu family. The one who asserts has to prove that the property is a joint family property. If, however, the person so asserting proves that there was nucleus with which the joint family property could be acquired, there would be presumption of the property being joint and the onus would shift on the person who claims to be claims it to be the jointly self-acquired property to prove that he purchased the property with his own funds and not out of the joint family. So the nucleus has to be there, my lord. It's in any event, my lord, about the Vitakara families, basically. Now, I would also, my lord, very interesting, my lord, like to rely on another Supreme Court judgment which says that, my lord, kindness or affection does not prove that there is jointness.
The elder brother brought the family members here.
They shifted undisputedly. They came later to in India. The elder brother, my lord, naturally. At least, my lord, in 60s, it was natural.
Quite natural. Even in the whole village depends upon that person has went there.
I would like to rely on, my lord, AIR 1968 Supreme Court 1276. SCC online এ থাকবে এরকম দেখো 68 তো হ্যাঁ হ্যাঁ Kindly come to paragraph 6. এই প্যারাগ্রাফটা দেখতে ওই সময় মেলে কিনা প্যারাগ্রাফ 6 কি দিয়ে শুরু হচ্ছে We will tally. Paragraph 6, my lord. We pass on to consider the alternative argument put forward on behalf of the appellant, namely that even if the business of Ombika stores was started as a separate business of Munassami Raju, it became converted at a subsequent stage into joint family business. It was argued on behalf of the appellant that the business of Ombika stores was thrown by Munassami Raju into the common stock with the intention of abandoning all separate claims to it, and therefore the business of Ombika store lost its character of a separate property and was impressed with the character of a joint family property. It is a well-established doctrine of Hindu law that property which was originally self-acquired may become joint property if it has been voluntarily thrown by the co-personer into joint stock with the intention of abandoning all separate claims upon it. The doctrine has been repeatedly recognized by the Judicial Committee in such and such. But the question whether the co-personer has done so or not is entirely a question of fact to be decided in the light of all the circumstances of the case. Must be established that there was a clear intention on the part of the co-personer to waive his separate right. And, my lord, next portion. And such an intention will not be inferred merely from acts which may have been done from kindness or affection. Relied on Indian Appeal Privy Council. I shall now come to the decision cited by them. I do not want to burden your lordship with further cases. Kindly take.
But one
yes,
clear thing I want from you regarding that DW1, whether can prove the written statement case, because it relates to wholly what happened in 1960? What was the intention of the original, the owner and the person who alleged to have contributed in purchasing? What was their arrangement, the family arrangement, business arrangement, acquisition of the consideration price, payment? Whether the defendant number one can prove that in such a situation if we have an authority. Otherwise, we have to apply the general logic that you cannot prove it. It will come in the rim of the hearsay evidence.
I should have, but I will look into it.
Yes, then distinguish the judgments cited by.
Yes. Because I was, in fact, my lord, took it possibly lightly that neither the other brother, the third brother, nor the four sisters, they were called.
No, this was not an impossibility to prove the circumstances.
Absolutely.
The surrounding circumstances prevailed at the time when the property was purchased, because all the PCs, all the brother, all are available. Though defendant number one died subsequently, but they were available. And so far the in any event, the PW1 was not cross-examined from that angle also.
In fact, I intended to rely on one case that, my lord, uncontroverted evidence, my lord, that's really my evidence remained uncontroverted.
No suggestion was given even time of cross-examination.
Carapiet, they have relied on Carapiet, I shall rely on.
The same way. Now you distinguish it.
Yes, madam. Kindly come. There are two bunches. Kindly come there. Take the first bunch, madam.
No, two bunches
of judgments. হ্যাঁ, কখন ছিল? সাক্ষীতে ছিল। বিদ্রোহের সময় ছিল। Now kindly take, my lord, the first compilation. My lord, I have marked these and 1 and 2. Kindly see the page numbers. Lordship will find, my lord, there is a thicker bunch where, my lord, pages 1 to 115 are there.
Yes, 1942 Calcutta.
It starts with 42 Calcutta. Yes, my lord, that I have.
Mr. Banerjee, you have submitted written notes, but you have not referred the judgment and for the purpose of referring those judgments.
So because your lordship opined, my lord, that how far you
Argued. That was this.
that. Accordingly, I did it.
Not the complete argument.
Not the complete argument on point of law and others. That is to be fine, undoubtedly. But that will not serve the purpose. Lord, only your lordship's observation was that so that I cannot repeat.
Yes, understood.
I do not repeat.
Don't scare him. Don't scare.
My bad name is also there.
No. No, I never say that.
No, not that.
I never say
that. Not that.
Mr.
This
Banerjee,
is the skill of a lawyer. How is to
Absolutely,
mean?
absolutely.
Skill of a lawyer.
Tell your lordship, my
Yes,
lord,
I love to hear. This is skill, how to stretch it, how to.
to be very candid, my lord, I shall tell your lordship, I am envious.
Yes, 1942 Calcutta.
No, kindly first, my lord, I shall slightly go in some other way. Now kindly come to, my lord, serial number 9 first.
56 Supreme Court.
Lordship.
Yes.
My lord, reliance has been placed on paragraph 11 of this judgment.
Page 64.
My lord, it is page 64.
Give me.
Let's kindly come to paragraph 8 first. Notwithstanding the tangle of legal proceedings.
Paragraph, just wait.
8.
This is page 64.
Page 66, madam. Starts at page 64.
Paragraph
8. Notwithstanding the tangle of legal proceedings extending over 30 years, which forms the background of the present litigation, the single and sole question that arises for decision in this suit is whether the sale deed dated 30th January 1920, under which the appellant claims is subject to the result of sale dated 2nd August 1928, in execution of the decree in original OS number 100 of 1920, by reason of the rule of lispendence enacted in section 52 of the Transfer of Property Act. If it is not in dispute that it becomes avoided by the purchase of so-and-so and 2nd August 1928. If it is not, it is equally indisputable that the appellant as purchaser of the equity of redemption from so-and-so have a right to redeem the mortgage deed dated such and such, and not having been implemented in such and such, and not bound either by the decree passed therein or by the sale in execution thereof. Then kindly come to paragraph 10. The question of lispendence was raised by the plaintiff at the very commencement of the trial on 8th March 1947. When he went into the witness box and filed in his examination in Chief Exhibit J series relating to the maintenance suit, the decrees passed therein, and the proceedings in execution thereof, including the purchase by Devamma. This evidence is relevant only with reference to the plea of lispendence, and it is significant that no objection was raised by the defendant to its reception. Nay more, on 13th March 1947, they cross-examined the plaintiff on the collusive character of the proceeding in Exhibit J series and filed documents in proof of it. The trial went on thereafter for nearly 3 months. The defendant adduced their evidence and the hearing was concluded on 2nd June 1947. In the argument before the district judge, far from objecting to the plea of lispendence being permitted to be raised, the defendant argued the question on its merit and sought a decision on the evidence that the proceedings were collusive in character, with a view to avoid the operation of Section 52 of the Transfer of Property Act. We are satisfied that the defendants went to trial with full knowledge that the question of lispendence was in issue, had ample opportunity to adduce their evidence thereon, and fully availed themselves of the same, and that in the circumstances, the absence of a specific pleading on the question was a mere irregularity, which resulted in no prejudice to them. Then, my lord, paragraph 11 was relied on. Only paragraph 11. It was argued for the appellants that, as no plea of lispendence was taken in the pleadings, the evidence bearing on that question could not be properly looked into, and that no decision could be given based on Exhibit J series, that the sale dated 30th January 1920 was affected by lease, and reliance was placed on the observation of Lord such and such in Siddiq Muhammad Shah that no amount of evidence can be looked into upon a plea which was never put forward. The true scope of this rule is that evidence let in on issues on which the parties actually went to trial should not be made the foundation for decision of another and different issue, which was not present to the minds of the parties, and on which they had no opportunity of adducing evidence. But that rule has no application to a case where parties go to trial with knowledge that a particular question is in issue, though no specific issue has been framed thereon, and adduced evidence relating thereto. The rule applicable to this class of cases is that laid down in Rani Chandra versus so and so, there the defendants put forward at the time of trial a contention that the plaintiff had been given away in adoption and was in consequence not entitled to inherit. No such plea was taken in the written statement, nor was an issue framed thereon. Before the Privy Council, the contention was raised on behalf of the plaintiff that in view of the pleadings, the question of adoption was not open to the defendants. It was held by Lord Atkinson, overruling this objection, that as both the parties had gone to trial on the question of adoption, and as the plaintiff had not been taken by surprise, the plea as to adoption was open to the defendants, and indeed the defendant succeeded on that very issue. This objection must accordingly be overruled.
What is the relevance of this paragraph?
It was, my lord, sought to be, my lord, said that this decision was relied on to contain that even without pleading, the court can look into, my lord.
Oh, that to bring that that new case of joint state.
And the Sikmi.
And the Sikmi. Sikmi is not born out of the
Nowhere. Joint estate, yes, the parties have laid evidence. The parties, I have said. Enemy
there was no joint business that has been dealt with by the appellate court also. Yes, then
next, my lord, kindly come to AIR 1966 Supreme Court 735, same bunch, my lord, page 47.
Possibly 6, 7, and 9 on the same proposition.
6, 7.
Possibly, as my marking shows.
'56, 593, yes. Then 52 Supreme Court. I'll check, my lord. I'll check. '66 Supreme Court, yes. 7 and 9, definitely, my lord. I'll check, my lord. Whether 52 also comes within it. Now, kindly come to page 47. My lord, paragraph 10 has been relied on before your lordship.
Which judgment?
AIR 1966 Supreme Court 735, my lord, which is 7. Your lordship indicated.
Yes.
Page 47 of this batch.
Paragraph 10.
Yes. They have relied on paragraph 10. Kindly come to paragraph 9 once, my lord. Paragraph 9, page 49. There can be no doubt that if a party asks for a relief on a clear and specific ground, and in the issue or at the trial, no other ground is covered, either directly or by necessary implication, it would not be open to the said party to attempt to sustain the same claim on a ground which is entirely new. The same principle was laid down by this court in Shridhar Rai versus such and such. In that case, it was held that where the defendant in his written statement sets up a title to the disputed land as the nearest reversioner, the court cannot, on his failure to prove the said case, permit him to make out a new case, which is not only not made in the written statement, but which is wholly inconsistent with the title set up by the defendant in the written statement. Exactly, my lord, here. Ownership and Sikmi, my lord, are wholly inconsistent. The new plea on which the defendant sought to rely in that case was that he was holding the suit property under the SICMI settlement from the nearest reversioner. It would be noticed that this new plea was in fact not made in the written statement, had not been included in any issue, and therefore no evidence was or could have been laid about it. In such a case, clearly a party cannot be permitted to justify its claim on a ground which is entirely new and which is inconsistent with the ground made by it in its pleadings. My lord, I would say, my lord, identical.
Yes, but the settlement, Shikimi settlement has got a peculiar characteristics. That is why as soon as it came to my notice, this was not taken. Rather, I put him the question whether this was, and he developed it from there.
Yes.
He developed it from there. But this character of the settlement is really something akin to ownership. Character of the Shikimi settlement. But nonetheless, now no such case has been made out. No evidence was laid except this record of rights, which has not been relatable with the suit property.
No. Number one and number two, my lord, it was tendered in evidence. That's it.
It has not been asserted even by the
No, no.
defendant that I know.
Forgetting about, my lord, pleadings. I could have understood, my lord, as he said, my lord, in the earlier case, that if you have laid evidence to that effect.
No evidence was laid. Even the DW1 never said that. He said that I was not aware what was really happened
Exactly
there.
why I'm scared of Mr. Banerjee. I really do not know where from what would be coming. Now kindly come to paragraph 10 relied on by them. But in considering the application of this doctrine to the fact of the present case, it is necessary to bear in mind the other principle that considerations of form cannot override the legitimate consideration of substance. If a plea is not specifically made and yet it is covered by an issue by implication, and the parties knew that the said plea was involved in the trial, then the mere fact that the plea was not expressly taken in the pleading would not necessarily disentitle a party from relying upon it if it is satisfactorily proved by evidence.
No, in fact, you were taken by surprise.
Absolutely.
You were taken by surprise. Sikkim is far away from Uttar Dinajpur. How we can relate it? No, actually, I wanted to know from both of you that if is the character of this Sikkimi, then is there any case made out that the ownership rests on this such recording to me without being objected by the owner, that his name should not be recorded in such? Now, from the record, it appears that at least the Khatiyan deferable to this Sikkimi
is different.
Is different. At least it is not relatable with the suit property. Yes, then.
And my lord, as held by the courts, my lord, by the Supreme Courts, pleadings, yes. Even without pleadings, if you say in oral evidence that, then my lord, the other party gets an opportunity to explain, to give the answer to it. There was not a single whisper about this Sikkimi. Nothing.
Yes, it reminds me that Nagubhai HON'BLE has been, I have dealt with in a recent judgment I have delivered. that absence of pleading is not so fatal that if the parties are aware that what cases they have to meet, then merely because this formal pleadings is not there, will not, is not so fatal that you will vitiate the entire judgment.
Yes.
The general principle is there.
Doing justice, that you have to meet this point.
So now 66, what about the 66?
Well, rest of the paragraph, my lord, may I
Yes.
hurriedly go through it? I was towards the middle. The general rule, no doubt, is that the relief should be founded on pleadings made by the parties. But when the substantial matter relating to the title of both parties to the suit are touched, though indirectly or even obscurely, in the issues and evidence have been laid about it, in the issues and evidence has been laid about them, then the argument that a particular matter was not expressly taken in the pleadings would be purely formal and technical and cannot succeed in every case. What the court has to consider in dealing with such an objection is, did the parties know that the matter in question was involved in the trial? And did they lead evidence about it? If it appears that the parties did not know that the matter was in issue and at the trial, and one of them has had no opportunity to lead evidence in respect of it, that undoubtedly would be a different matter. To allow one party to rely upon a matter in respect of which the other party did not lead evidence and has had no opportunity to lead evidence would introduce consideration of prejudice, and in doing justice to one party, the court cannot do injustice to the other. But this is the paragraph they have read.
Now, Mr. Banerjee possibly wanted to put it in that form that the record of rights were on the record. There was a recording of Sikimi Patta. The appeal court has not considered that.
No evidence was laid. Well, I could have understood that this point was taken. That look here, this land
in the trial, no. In the appeal, no. Record of rights, trial court considered the record of rights.
Trial
Possibly.
Yes, he was a student.
Only source of consideration.
He was.
Then the what about this judgment of 66, Bhagavati Prasad? Is it the same with the same tune?
66 is, my lord, the one I dealt with.
No, sorry, 52. 52.
52, my lord, kindly, my lord. It's 34.
52. Delete and block because there are 16 or 20 judgments. Huh?
Kindly, my lord, kindly give me this time. No. My lord, possibly, my lord, page 45, Reliance has been placed on page 45, second paragraph, or the first paragraph, in fact.
Page 45, this is a continuation.
Yes, my lord, it starts at page 34.
This has been taken from where?
52, I do not know, my lord.
Printout taken for somewhere.
It starts at page 34. Kindly come to, my lord, page 45 at the top. The plaintiff has also asked for a declaration of charge and for a decree under Order 34 Civil Procedure Code. The declaration of charge standing by itself is superfluous, although Order 34 Rule 2 Sub Rule 1 does require that the decree in a mortgage suit shall such and such declare the amount so due at the date of the decree. But reading the two reliefs together, I am of opinion that though the claim is inartistically worded, the plaintiff has in substance asked for a mortgage decree up to a limit of rupees 40,000 with interest against each defendant. No other kind of decree could be given under Order 34. Therefore, though he has not used the word subrogation, he has asked in substance for the relief to which a subrogee would be entitled under the Transfer of Property Act. I would be slow to throw out a claim on a mere technicality of pleading when the substance of the thing is there and no prejudice is caused to the other side. However clumsily or inartistically the plaint may be worded, in any event, it is always open to a court to give a plaintiff a general or other relief as it deems just, to the same extent as if it had been asked for, provided that occasions no prejudice to the other side beyond what can be compensated for in cost. This is the portion possibly what was relied on. Subject to correction, my lord.
The next one?
Next, my lord, is the possibly on the right of Shikmi holder. I'll kindly come to page 94 of the first volume, my lord.
Serial number?
My lord, it is serial number, my lord, 11, 32 CW and 241. Kindly come to, my lord, the facts, my lord. First, page 95, my lord. This appeal must be dismissed and for the following reasons. The appeal arises out of an action brought by the plaintiff firm for a declaration that a certain indenture
Mr.
of
Mito, it has been relied on only to elaborate or to show that what is the meaning of the word kaemi at page 243. There is no dispute. Kaemi means, it means permanent occupancy holding. That I told you, Lordship. Sikimi Patta has a character of kaemi.
Page 243, yes, my lord. the latter part of.
Yes, tenants right in the land as stated, it means a permanent occupancy holding. There is no dispute, very well.
The word kaimi is never used as far as I know in describing jomindari interest in land by any person. The word is always used in connection with the description of tenants right in land, and as stated above, it means a permanent occupancy
It's
holding.
permanent occupancy right. No doubt, very well. You have to meet out this case.
Absolutely. That is why, my lord, I said that these cases, my lord, in my respectful submission have no application. Because, my lord, that case was nowhere made out.
He came to Mr. Banerjee late. Yes, the next one.
Next one is, my lord, kindly come to page 98.
Item number. This is possibly.
My lord, this is
22
CW1
CWN.
618.
No, this is 98.
Huh. 22 CWN 618. Kindly come to page 98 at the bottom, my lord. So, my lord, on appeal, by the defendants, the subordinate judge decreed the appeal and dismissed the plaintiff's suit. The following portion of his judgment will be found material to this report. Kindly omit the first paragraph, kindly come to the second paragraph. Occupancy right, as I understand, it is a right to remain in occupation of the land against all the world, including the landlord. But the law has clothed the landlord with a certain right to evict even the tenant with a right of occupancy upon specified grounds. On no other ground can a tenant with a right of occupancy be ejected. To hold otherwise is to destroy the very foundation of the right of occupancy, which in its essence is a protection against ejectment. When an underwriter acquires a right of occupancy, he is not thereby raised to the status of an occupancy right, but he is protected from ejectment. In all other respect, he remains an underwriter and is subject to all the liabilities applicable, etc. Now, my lord, as I have already submitted before your lordship,
Yes.
Kindly give me a minute.
বন্ধ করতে বলা হবে।
And my lord, this case has not only
Possibly you are not disputing their situation.
No, I am not
That
required
occupancy
to.
right recognized under a statute. And it has got something that it cannot be evicted, acquired any customs. A right of occupancy is a creature of a statute.
I am not, my lord, denying the principles laid down here, number one. Number two, in any event, my lord, as I have already said, that, my lord, this case was not made out, number one. And number two, this is, my lord, totally contrary to the case made out. Ownership, right as a co-owner. And occupancy right as a right.
Yes, yes, yes. We come to the 13. Next one.
Yes.
32 TCW and 22 CW and you have dealt with.
Yes. Next one is, my lord,
which one?
Is again, my lord, on SICMI, my lord, according to me, my lord, page 106, that is 14.
31 Patna.
31 Patna. Dumasi. But kindly consider paragraphs 1 and 4. These appeals arise out of 4 suits relating to 4 different parcels of land. The plaintiffs in all these suits claim to have the right of occupancy in the lands in dispute and prayed for a declaratory decree to this effect. The defendant, on the other hand, contended that the plaintiffs were mere under-tenants with no right of occupancy and that there was no custom in the village which would confer the right of occupancy upon under-tenants. Now, it is common ground that there are 2 records of right for the Saran district where the lands are situated, one prepared during the cadastral survey and the other during the revisional survey. In the cadastral survey records of right, the plaintiffs are recorded as under-tenants possessing what is described therein as hak mukab, whatever it is. All the courts below are agreed that this expression means right of occupancy. And it is not disputed, therefore, that the cadastral survey...
Yes, yes, under-tenant. Under-tenant, no doubt under-tenants. They are under-tenants. If it is recorded as SICMI tenant.
Paragraph 4, kindly see.
Yes, next one.
Next, my lord, on this, my lord, kindly come to the second volume, my lord, second part. My lord, kindly come to serial number 2. Sorry, no, not 142. Serial number 4. Kindly come to paragraph 2, my lord. It speaks about section 48D of the Bihar Tenancy Act. Then paragraph 4 it is not in dispute that one Sarjuk Das, the father of the petitioner, was having his possession over the land in dispute as Sheikh Mother. Then it goes on, my lord, paragraph 5, the case of the petitioner is that after the death of her father, namely so-and-so, she being her heir and legal representative has inherited the land in dispute as Sheikh Mother, and therefore she became the occupancy under the meaning of section such and such of the Bihar Tenancy Act. The petitioner being an occupancy, etc.
Dangerous thing is paragraph 12. It is heritable but not transferable. If that be so, land comprised in Sikkim and purchased in 1960. Defendant number 1 is attacking the title. The sale deed itself. It is not transferable. It has been held here that it is heritable but not a transferable right. So vendor of the plaintiff had a Sikkimi right. He not have a right to sell the property.
The document does not say that. I showed you.
Document does not record that it is a Sikkimi right. Anyway, these are the character of the Sikkimi right. Whatever the judgment he has cited is relatable to.
Next is, my lord, at page 145.
Let me take a note of it. 2006. This is 2006, no? No.
2013. SCC Online Partner 1055.
Then these are the judgments on Sikkimi.
Yes.
52 Supreme Court, 66 Supreme Court.
Sikkimi, my lord, divorce pleading. Sorry, 56 Supreme Court, 66 Supreme Court. These are, my lord, point divorce pleading.
Divorce, and what are the Sikkimi?
Sikkimi, my lord, starts from 22 CWN, then 32 CWN,
31 Patna.
31 Patna. Those are in the first volume, and then in the second volume, my lord, 2013 SCC Online Partner, then 2006 SCC Online Partner, and then 1907 SCC Online Allahabad.
This is 23 SCC Online Partner.
Then 2006 SCC Online Partner 209, which is at page 145 of the compilation.
Then
the third one is, my lord, 1907 SCC Online Allahabad at page 154.
So you conclude this Sikkimi part today. Yes. Then 2006.
Yes.
Page 145.
145, my lord.
Sikkimi under right.
Yes.
This is also the same proposition. The Sikkimi right is under right.
Yes.
Sikkimi tenant. Then again Allahabad.
Yes. Now, only, my lord, kindly once come to, my lord, page 145, paragraph 3.
Yes.
The case of the plaintiff respondent in brief is that he is a representative of Karta of joint Hindu family governed by such and such. The suit land described in Schedule 1 of the plaint was owned and possessed by him. He has been coming in possession thereof during the survey, which was finally published on such and such. The suit land was recorded in the name of so and so, resident of Mohalla such and such Bhagalpur. The name of Shia Mahatan, the father of the defendant number 1, was recorded as non-occupancy under wrath only for a temporary period of 2 years during the survey proceeding, and accordingly a Sikkimi khata was opened. So it's not that, my lord, it has to be Be that as it may, my lord, again. The nature of.
No. If you come to paragraph 13,
Lordship. In the opening chapter of.
no, if you come there, the Sikimi indicate, the word Sikimi indicates under Rayat,
Yes.
meaning thereby Shia Mathan was under Rayat under the recorded tenant Marwari. He has been shown as Gair Dakhalikar for 2 years. So under Rayat qualified with an entry Gair Dakhalikar for 2 years, meaning thereby that Shia was a non-occupancy right with respect to the suit land and was holding the land for 2 years.
And as such, on the basis of the entries made in the records of right, I do not find any difficulty in holding that at the time when the survey Khatiyan was published on such and such, Shia Merton, the ancestor of the defendant, had no occupancy right.
Therefore, these are the qualified recording of a Sikkim land. It may vary from entry to entry. So nonetheless, this is the under Rayat. He is the under Rayat. Now, this is anything more on this Sikkimi?
The my lord, Allahabad, my lord, page 154. The first paragraph, kindly see the sole question for determination in this appeal turns upon the meaning to be assigned to the expression Shikmi shareholder used in Wazib Ulars of village such and such. In the Saharanpur judgeship. On the part of this is the scope.
This is another completely different, completely different. Not very helpful for our purpose in this second appeal. So this is all about Sikkimi. So you have the task of distinguishing how many?
20. No.
How much left?
22. I could deal with my lord 6 and 3, 9. I will not take long.
Is a bunch. Mr. Roy, do one thing. These are the points on Sikkimi. Club it together in one page and hand it over to me. When? Consult your diary also, please.
Right. Yes, Lordship.
9 2 p.m. for further hearing.
Because 9th, I have difficulty with that.
Instead of 9th, it can be Milord.
11th, 12 o'clock. So Banerjee, at least we can go up to first half at from 12 to 1:30, we can 1.5 hour, Mr. Banerjee.
আপনার ওটা কবে ডেট ফিক্স হলো? হলো বলছে। তাহলে তো ঠিক আছে হলো।
আচ্ছা। হুম? 12 o'clock. এগুলোকে তো আলাদা করে রাখবেন। 11, 12 o'clock. If Mr. Mitro can conclude it, his submission, you may start on that day. It may not be possible for you to conclude, but I can spare up to first half, second half, other matter fixed.